All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today's Thursday, February 26, 2026. We have 8 bills on the docket, and we're going to start off with Senator Hershey with Senate Bill 835. Welcome.
Well, thank you very much, Mr. Chairman and members of the committee. For the record, Senator Steve Hershey to present Senate Bill 835. This bill requires that beginning fiscal 27, the Cecil County Council is to determine the annual salary and expense allowance for a judge of the Cecil County Orphans Court. The annual salary must be at least $11,000, and that's up from $8,750, and the allowance for travel expenses must be at least $1,500. Further, the chief judge must receive additional compensation of at least $1,500 in an amount determined by the council. Pursuant to the constitutional requirements, this increase takes effect at the beginning of the next terms of office. This bill is sponsored and supported by the Cecil County delegation, the Cecil County executive, and for these reasons, I ask for a favorable consideration of Senate Bill 835.
Excellent. Thank you very much, Senator. Are we in receipt of the delegation letter? Yes. All right. Cool. Any other questions from the committee? All right. Thank you very much, Senator.
Very much.
Thank you.
Appreciate you fitting me in.
Excellent. All right, we're going to go with Senate Bill 933, just really quickly. This will be extremely quick. Senator Smith here to introduce Senate Bill 933, which is a constitutional amendment. Last session, the General Assembly passed a constitutional amendment giving the governor the authority to appoint temporary substitute members of the Judicial Disabilities Commission in the event of a member's recusal or disqualification. The commission is comprised of 11 members, and they have oversight of every level, every tier of our judiciary, and they are tasked with, among other things, disciplinary matters for the bench. And so what this bill does is it says that if someone has been rejected by the Senate, that the governor cannot make an interim appointment of that member of that commission. It's really what I view as a loophole in the amendment that we have that's going to be on the ballot next election. So this is an amendment that will tighten up that loophole so that if someone is rejected by the Senate, a governor cannot appoint that same person without, again, our advice and consent. And that's the sum and substance of the bill. And with that, I'll ask for a favorable committee report and stand by for questions. Excellent. Thank you. Okay, looks like we're now going to go on to, if Senator West, are you, if you can go? Okay, so we're going to go Senate Bill 658.
Mr. Chair, could I call up my panel? Panel? Everybody, all the favorites, what's going on?
We'll find the other two. You guys going early, which is totally fine. Let me just find the other two.
Mr. Chair, it's a pleasure to be here to present Senate Bill 658. This legislation makes targeted, child-centered changes to the responsibilities of the Department of Human Services when it serves as a representative payee or fiduciary for children committed to its custody. It's a highly technical 6-page bill, but the overall theme is to improve and enhance protection offered to children committed to the custody of the department. The need for stronger protection is urgent. Young people aging out of foster care continue to face significantly poorer outcomes than their peers. They are less likely to earn a high school diploma or post-secondary degree, and more likely to experience housing instability, unemployment, involvement with the justice system, and reliance on public assistance. Among youth experiencing homelessness, those with foster care histories are disproportionately represented and face compounded challenges. Conserving and protecting children's federal benefits is both transformative for young people and fiscally prudent. Ensuring that youth leave care with more resources strengthens their transition to adulthood and reduces long-term reliance on public assistance. So under current law, when a child in DHS custody receives federal benefits, such as supplemental security income, Social Security benefits, or benefits from the Department of Veterans Affairs, the Department of Human Services may serve as the representative payee. But for children up to the age of 14, the statute currently allows the department to use all of a children's benefits to reimburse the state for the cost of care of the child. For children 14 and older, the statute only requires that a portion of those benefits be used on behalf of the child. The rest of the benefits currently must be paid to the state. While Maryland was the first state in the country to partially protect these benefits from being paid to the state, instead of being used or conserved to fulfill the unmet needs of the beneficiaries, our law currently stops short of fully protecting these benefits. So Senate Bill 658 clarifies and updates these provisions to ensure that all of these benefits are used or conserved in a way that reflects the child's current unmet needs and are managed in the best interest of the child. The bill defines unmet needs to include essential items of services beyond those provided by the department, such as needs relating to a child's disability, housing expenses, transportation expenses, tuition expenses, tutoring expenses, and training costs. Senate Bill 658 directs DHS to try to identify an appropriate representative payee of such federal benefits before the department assumes that role, and it requires documentation of those efforts. The bill requires either the department or the alternative representative payee to use the child's benefits for the child's current unmet needs that may not otherwise have been paid for as part of the child's care or covered under the child's health insurance, or else to conserve the benefits for the benefit of the child. The bill also enhances transparency and accountability by requiring DHS to determine eligibility for federal benefits within 60 days of a child entering care and annually thereafter, to seek coverage for required eligibility screenings, and to notify the child through counsel of benefit applications, decisions, and appeals. Importantly, this bill is designed to protect and support children in DHS custody by making sure federal benefits intended for them are used to address their current and meaningful needs, rather than for administrative processes or reimbursement. This bill ensures that benefits are used in ways that truly support the child's well-being and prospects for stability and success. I appreciate the committee's consideration of this bill and be happy to answer any questions, but in the meantime, we have a three-person panel led by Ann Seacott, an old friend who I worked with very actively when I served on HGO in the House, and it's such a pleasure to have one last chance to work with Ann on this bill. I give you Ann Seacott.
It's going to get me misty. Hi, I'm Ann Seacott. Today I'm representing the National Association of Social Workers. We have another client who's going to be providing testimony, the Children's Advocacy Institute, in strong support of this bill. My role here today, and then I'm turning it over to other experts, is to let you know that we are in discussions with the Department of Human Services. We certainly are aware of the fiscal note. The conversations that we have had, and I think they would not accuse me of misrepresenting them, is that on a policy level, we're on the same page. We have worked on amendments that address some very technical pieces, important and technical pieces of the bill. We are awaiting the language to be able to get to the senator and share with everyone. So it won't get it a zero fiscal note, but it will bring the fiscal note down. And then we can talk about if there's anything else we can do to the bill. So it's just to let you know that Maryland has done such a great job in leading the path in being one of the first states, or the first state to do this to a partial degree. And we're here to say, let's go all the way and make sure that young people have access to the resources that belong to them to meet their needs and to help them transition into independent life after foster care. So I'm bring up the next witness.
Good afternoon, everyone. My name is Amy Harfeld, and I serve as the National Policy Director for the Children's Advocacy Institute. I'm also a proud resident of District 18. I am here today in support of SB 658. This would protect foster youth from being stolen from. The practice that is being practiced right now in Maryland, when my son saw me interviewed on TV about this, he was 9, and he said, "Mommy, that sounds like stealing." And I said, you know, when you take something that's not yours, that's what we call it. I first learned about this practice when I was representing a 17-year-old in care in New York. She wanted to emancipate early and wanted to access her savings funds to pay her tuition deposit. She didn't have access to it, and she wanted to know where her money went. And I said, well, your benefits and assets went to the state. And she said, well, how come I never knew about it? And I said, well, right now, they're not required to tell you. But I will fight this until it happens across the country. So that is what I've been doing for a very long time. Maryland was the first state to address this issue in 2018. And since that time, we have helped usher in reform to 37 states across the country. 12 states have fixed it entirely, and many others have already gone further than Maryland. We want to highlight that the tiny fiscal note attached to this is fairly easily addressed by accessing other federal funds that Maryland really isn't looking at, including Chafee funds for transitional youth, 4E administrative costs, which also cover legal protection, and Medicaid. I'm happy to answer any questions that you might have. Thank you.
Good afternoon, Chair, Vice Chair, and esteemed members of the committee. Thank you for hearing us today. My name is Chloe Kastner. I am a student at the University of Maryland, Baltimore School of Social Work, and here on behalf of our coalition, Social Work Advocates for Social Change, in favor of SB 658. Children in our foster care system don't pay to be in our foster care system unless they're disabled or they've lost a parent. This bill seeks to correct an inequity where survivorship benefits from SSA and Veterans Administration are taken by the state to recoup the budget. In these cases, the state of Maryland can take up to 60% of these benefits to pay for the foster care. These are children who 1/3 of them face homelessness by age 21 after aging out. More they have less opportunity for education, more interactions with the criminal justice system, and this practice continues to hurt them and create barriers for them as they enter adult life. SB 658 would put these benefits back where they belong, in the hands of the children that they're entitled to. This provides better long-term chance at stable housing and a successful transition to becoming an adult. And for these reasons, Social Work Advocates for Social Change urges a favorable report on the bill. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Nina Villamar, and I'm the Chief of the Parental Defense Division at the Public Defender's Office. We represent parents across all 24 jurisdictions whose children are in or at risk of entering foster care through Senate proceedings. Senate Bill 658 addresses a quiet but important issue that affects some of the most vulnerable children in our system. When a child in foster care receives Social Security or survivor benefits, often because a parent has died or the child has a disability, the Department of Human Services can apply to manage that money as the child's representative payee. Right now, the department is allowed to use those federal benefits to reimburse itself for the cost of the child's foster care. So in practice, some of the only children who are required to help pay for their own care are children who are orphaned or who have significant disabilities. Senate Bill 658 simply says that those benefits should be used in the child's best interest for things like tutoring, assistive technology, extracurriculars, medical support, or even saved to help that young person transition successfully into adulthood. We know that youth aging out of foster care often face a financial cliff. Preserving those funds can mean the difference between having a security deposit for an apartment or becoming homeless. This bill also requires the department to consider whether a trusted adult or a relative can serve as a representative payee before assuming that role itself, which helps reduce an inherent financial conflict. These benefits belong to the child. Senate Bill 658 ensures that they are used to support that child's present needs and future stability. For these reasons, we respectfully request a favorable report, and I'm happy to answer whatever questions you may have. Thank you.
Excellent. Thank you very much. All right, I did have, is Erica Lamont?
Yes, we have one additional witness.
Yes.
We might as well do them all, and then we'll all answer questions.
Welcome.
Thank you, Chair. Good afternoon, committee. My name is Erica Lamont. I'm the Advocacy Director from Maryland Legal Aid. I oversee our center work. Maryland Legal Aid represents thousands of children in Senate and guardianship proceedings across the state. We advocate for and beside young people from infancy through transition to out of foster care. We know firsthand how fragile that transition can be and how critical it is to provide the modest financial resources for our young children who are trying to build a stable life. Before I proceed, you heard one of the witnesses talk about the fiscal note for certain things, if you provide assistance earlier, it will remove the need for financial assistance later, and this is one of those things. Thank you so much to the sponsors for making this simple but profound clarification. A child's federal benefits belong to the child. SB 658 requires the department to consult with the child's attorney when selecting a representative payee, to monitor that payee and to replace them if necessary to protect the child's best interests. It limits the use of those funds to a child's unmet needs beyond what the department or medical insurance must already provide, and it requires that any remaining funds be conserved for the child until the child exits foster care. Youth who age out of foster care face staggering barriers, some of which you heard earlier, but I would also like to address that 1 in 5 will not have earned a diploma or credential by the age 21. By 26, their earnings are 50% lower than their peers and their employment rates 20% lower. For these young people in care, the benefits that this bill would provide are immeasurable. And so we request a favorable report. Thank you.
All right, thank you very much. Questions from the committee for the proponents of the bill? Seeing none, thank you all very much.
Thank you.
Thanks. All right, so that'll conclude the testimony for the proponents of the bill. We do have one person signed up favorable with amendments. Is Michelle Mervis here? Sorry, Mitchell, sorry.
He was across the street.
Oh, really?
He just couldn't get back over here.
Okay. I assume the committee has his amendments in the committee file? Okay. All right, well, that will conclude the hearing for Senate Bill 658. I see Senator Quarterman is here, so we're going to go on to Senate Bill 711. Open 24/7, 7-Eleven.
All right. Chair, do you mind if I bring my panelists up with me too? Thank you. Thank you, Mr. Chairman, Vice Chair, members of the Judicial Proceedings Committee. Thank you for the opportunity today to present Senate Bill 711, Family Law Child Neglect Definition. For the record, Senator Paul Quarterman, representing District 2, Washington and Frederick counties. Senate Bill 711 would expand the definition of child neglect under Maryland law to include a parent or a caregiver's failure or refusal to provide a child with education as required by law. It ensures a child's right to education is upheld. When those who are entrusted with a child's care, they are obligated to make sure that child receives the necessary education they are entitled to. The bill adds educational neglect to the existing forms of neglect recognized in statute. Recognizing educational neglect in statute is important because consistent school attendance is fundamental to a child's development, their safety, and their long-term well-being. Clarifying that aspect to education as a basic responsibility helps ensure that the children receive the support and oversight necessary to prevent long-term academic harm and related social consequences. Many other states have recognized and codified educational neglect in statute. 24 states have educational neglect statutes, including but not limited to New York, New Hampshire, Delaware, West Virginia, Oklahoma, just to name a few. All too often, children, though, are never enrolled, and those are the ones that are often left behind. Tragically, in 2023, a Hagerstown child, a 6-year-old, was starved to death at their home. Unfortunately, this child was never enrolled in school, and this bill, we hope, could have avoided that tragic incident. Now, you're going to see an unfavorable report from the Department of Human Services. I feel this is solely based on how they have perceived that their workload is going to increase. The delegate, who is the cross-file in the House, and I met with DHS on multiple occasions, the most recent just being a few weeks ago, just prior to the department responding to DLS for the physical note. Unfortunately, our conversation came down to, if we do this, our workload is going to increase dramatically. I challenged the department then, we challenged this committee. That's the exact reason of why we need the legislation. If only 1 out of 10 of these investigations resulted in a child avoiding the tragic incident we talked about before, it would be well worth it. The response, as you'll see, we got a physical note of $338 million, which those have been around for a while. Yeah, that's basically a, yeah, we don't want to do this. Now, I find that very concerning because that department is exactly who should be doing this. On the bright side, we have worked with our local Board of Education. You'll see a favorable with amendments from them, kind of narrowing it maybe a little bit more. And actually, Ms. Snodgrass, who you're going to hear from here soon, she and I talked earlier today about even making it a little bit smaller, and we will obviously submit those amendments to the committee for consideration to try to narrow that definition and hopefully appease the concerns of the department. We'd like to thank you for the consideration of the bill and respectfully ask for a favorable report.
Good afternoon, Chair. My name is Caitlin Snodgrass. I live in Hagerstown, Maryland, and I've been pushing for Maryland to become the 25th state to codify educational neglect ever since I met a 7-year-old boy who became involuntarily withdrawn for the second time in his life at only 7 years old for consecutive absences. He proceeded to miss the next 3 consecutive years of school, and I tracked him through 3 states for 2.5 years trying to mitigate that situation, and he is now in Maryland State foster care. His life is tremendously better, but Maryland has designed a system that allows children to easily fall off the radar of public schools with minimal effort to return them to the classroom. And we are the second richest state in the country, but we have an extremely high number of unaccounted children in our public school system. Please understand, when children, especially young children, do not have access to education, they're likely experiencing other forms of neglect and abuse. School can save children's lives. For the most unprivileged children in our community, it can be a lifesaver because they get to eat and because they are seen by mandatory reporters. I support this bill with amendment with the verbiage as follows. Neglect includes failure or refusal to provide education as required by law for children at least 6 years of age and who have not completed the 6th grade. Absences from school may not be considered abuse or neglect unless it causes the child to be involuntarily withdrawn from school and the school is unsuccessful in restoring enrollment. This will drastically decrease that fiscal note and focus on the younger children who are at higher risk of dying from maltreatment. Hagerstown had a 6-year-old boy starve to death. It takes a very long time to starve to death, and he was not enrolled. If we can get these kids in school, it actually can save their lives. Thank you.
Thank you both very much for your testimony. Questions from the committee for the witnesses? It's cold bench day. So, all right. Thank you, Senator. Thank you very much. Thank you for your testimony. Thank you both. All right. So that'll conclude the testimony for the proponents of the bill. We now have someone signed up in opposition. Is Maria Villamar here? Villamar? Welcome back.
Thank you, Mr. Chair. Long time no see. Good afternoon, members of the committee. Again, for the record, my name is Nina Villamar, and I'm the Chief of the Parental Defense Division for the Public Defender's Office. And we represent children in the entire state of Maryland when their families become involved in the child welfare system. I want to begin by saying clearly that children deserve access to education, and chronic school absence is a serious problem that should be addressed. And in fact, it is already addressed in existing Maryland law. It's a misdemeanor not to send your children to school. But Senate Bill 711 would shift that concern into the child welfare system, and that change would be accompanied with serious and unintended consequences. Right now, neglect is the legal threshold that allows the state to step into a family's life. In some cases, it even allows the state to remove children from their homes and their parents, separating them from their family. Senate Bill 711 means that issues like truancy, failure to enroll, or chronic absence could now fall under the neglect framework. But those issues are often tied with unstable housing, lack of reliable transportation, disability-related issues, bullying, lack of child care for younger siblings, or mental health concerns. But under Senate Bill 711, the consequence would, those issues would be treated as neglect. And the consequence is that more families would be drawn deeper into the foster care system, when what that family might actually need is support. Child welfare involvement should be reserved for circumstances where there is actual abuse or neglect or a substantial risk of harm, not where a family is struggling to meet compulsory attendance requirements in the face of systemic barriers. So for these reasons, we respectfully urge an unfavorable report on this bill. Thank you.
Excellent. Thank you very much. We have 2 questions. We have Senator Muse and then Senator McKay.
Thank you very much, and thank you for coming. Considering how important this bill is, my question is simple. Are there amendments that you all can make to the bill that will make it more palatable for us to, for you all to see this as a favorable bill?
Respectfully, Senator, we believe that existing law already provides the protections that children need.
Well, we have
in this
a lot.
regard.
I'm sorry. Go ahead.
I'm sorry.
We have an existing law for almost everything that we do. The goal here is to make it better, and we do that every day. And so give me another reason.
I don't believe that families should be drawn into the child welfare system for school attendance issues. I think that children could be protected if there were a stronger SINs, child in need of supervision statute, that were more robustly enforced. Currently, SINs petitions, as far as I know, are very, very rarely filed. And I think that that is one way that children can be protected from not attending school if SINs petitions were more filed. So in terms of an amendment to this particular bill, I'm not prepared to offer any suggestions because we so strongly are opposed to it.
Got it. I wish you all would sit down with them and look at something with the sponsor. This is a very good bill. I support this bill, and if there's any way at all that we can have a work group or a task force that can sit down and just work out some of these with the department.
I appreciate your
just
concern.
To try. Okay.
Thank you,
Thank you.
Senator.
You're welcome. Thank you, Mr. Chairman.
Mr. Chair, thank you for your testimony. Can you expand upon that this would draw more families into the foster care system? Are you just saying that the foster care system is completely broke? And I just don't understand. This bill is addressing a problem, and the public defenders are saying we can take care of it under existing law, which clearly we're not. And so your comment of being drawn into foster care, can you explain upon that?
Certainly. We don't believe that foster care is the answer to a lot of these families' problems. Foster care means that there is a court case that's initiated against the family. They are now being policed by the Department of Social Services. All of their actions are being scrutinized by the government. And there's the very strong and real danger of children being taken away from their parents and placed in foster care. We don't think that that's the answer to these systemic issues. We believe that providing more supports to address the problems that are causing failure to attend school is the better answer. It's better for the families, it's better for the children, and frankly, it's more cost effective for the state to the extent that that's a consideration, and I think that under our budget situation, that should be a strong consideration. So if a family is unable to send a child to school because they lack transportation, let's address it with supports by providing transportation. If a family is unable to send their child to school or doesn't send their child to school because the parents are suffering from mental health issues, let's provide supports to offer mental health treatment to those parents. Let's not have family separation be the answer to problems that can be fixed otherwise. Because I think that we all know by this point that separating children from their families results in trauma and has long-term effects that, that affect the children for the rest of their lives in adverse ways. So I do understand your concern, and I hear what you're saying. I would ask that we look at other solutions to the problem of school attendance.
Do you have any data that supports exactly what you just said?
Which part, Senator?
Oh, you just said a lot, but do you have any data that will support either using the foster care system? You had mentioned about systemic barriers. Is lack of education a systemic barrier?
Lack of education is a systemic barrier for children if they don't receive a good education. Yes, of course.
Would you say that receiving a good education has to do with attendance?
Yes, of course.
Okay.
I'm not contesting that.
But that's what is being received by this lonely senator on this committee. That it seems to me that the public defender's position is we're going to look out for the adult, we're going to look out for the parent, but be damned the child.
Not at all.
And I'm just saying that that's what is being received.
Yeah.
And so if you can supply some form of data that would support that the public defender is doing a wonderful job making sure that these children are not falling into the system that has been clearly defined. If you can come up with that, please, I'd love to see that, because I tend to believe that one of the systemic barriers is lack of education, and to not send your child to school. Whether it doesn't have to be public schools, it can be homeschool, those type of things, but it is the responsibility of government to make sure that the child is being offered some form of education. It seems to me you're more worried about, and I apologize for repeating, we're more worried about the parent. And to be perfectly honest, we got a lot of screwed up parents in this country. And I'll be darned if we're not going to pass a bill that's going to protect the child first, not taking them away. But if education is the key, how about we educate the parents to send their child to school? And I look forward to getting that data. Thank you very much.
We do have data that we can provide to you, Senator, and I will be happy to do that by email. To the extent that I conveyed that we don't care about the child, let me correct myself. Of course, we care about the children. We believe that preserving families is in the children's best interest. And so to the extent that I stand here before you as an attorney for parents, I can tell you that our position at the Public Defender's Office is that we represent parents because we think that parents make the best decisions for their children and that they are the best advocates for their children and that preserving families is in the best interest of children. Thank you.
I was, as I'm reading the letter of information from the Department of Human Services, they seem to be echoing pretty much what you're saying. And I can remember when I was in the House of Delegates, I had a bill to modify the truancy law because you had parents who were being prosecuted because their children weren't going to prison. One of the things that I note from this bill, schools, I'm sorry, thank you. I appreciate that. One of the things that I note on page 1, lines 22 is the definition of child. So we're talking about an individual that's under the age of 18 years. So we're really talking about not only children, we're talking about young adults, right? And one of the issues I remember from that hearing was dealing with a 15, 16, 17-year-old is not the same as dealing with a young child, right?
I agree.
So, and we're in this state because we expanded education or mandatory education from 16 up to being an adult. So, to me, I mean, and I think one of my colleagues had asked about other ways of dealing with this. Are you familiar with Education Article 7-301?
I don't think so off the top of my head, but if you could summarize it for me, it might ring a bell.
It says, and I'm reading the Department of Human Resources, Human Services, their testimony. They say that this particular act already describes parental requirements for ensuring a child receives educational services and establishes specific penalties for non-compliance. Does that ring a bell at all?
Not specifically, but it sounds sort of what I was saying about existing laws.
So it says instead of expanding the definition of neglect to trigger future CPS investigations, DHS believes that an alternative preventative approach leveraging existing community services and the DHS Family Preservation Program is more effective and family-centered strategy. Again, it sounds like you all are on similar paths. Would you agree?
We certainly are. That's essentially what I was saying as well. And I thank you for triggering my memory about this because I would hasten to add that currently the Department of Social Services can bring a SINA case on a child if educational neglect is one of the issues. I rarely see cases where it's the sole issue because often when there is educational neglect, it means that there are other problems in the home. So it's not as if children are being neglected totally. You know, there are cases that come in for other reasons, and then educational neglect is one of them. And so to that extent, the problem is already being addressed.
One other thing that they point out, and I'm hoping you can expound on this, it says altering the definition of child neglect would compel mandated reporters to make reports of said neglect to the department to which we would be obliged to respond. I'm assuming with the mandated reporters, they're talking about teachers?
Teachers, doctors, nurses, social workers, really almost anybody that the child comes into contact to. And if my understanding is correct, I think that everybody is required to report if they think that a child is being neglected. So really, there are a lot of watchful eyes on the child. And so anybody can file a report. Reports can be made anonymously. And then the Department of Social Services would be triggered to begin an investigation into that family. So, it would increase the workload for DHS. And I think that we should keep in mind that the more thinly they are spread, the fewer resources there will be for situations that you just heard about, like a child who's being starved to death, or a child who may be in serious risk of other types of abuse.
And in your testimony and in my question, we're not saying that education isn't important. Education is extremely important.
Absolutely, Senator. And I believe that I started off that way. We recognize the importance of education. I myself am a huge proponent of education, given my cultural background and my family history.
Thank you very much.
Thank you, Senator.
All right, thanks. Further questions from the committee? That was a helpful exchange, so thank you very much, Senator, and thank you both. All right, I think that's it.
Thank you.
All right, with that, that'll conclude the testimony in the hearing for Senate Bill 711. I see that Vice Chair Hayes is here, so we're going to go on to Senate Bill 819.
My heart is broken. Man, oh my goodness. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Senate Judicial Proceedings Committee. I'm Senator Antonio Hayes, representing the 40th Legislative District in Baltimore City. This is my first time in JPR this session, but I've seen many of you guys in Senate Finance. I know. So I'm here today on Senate Bill 819, Judicial in-rem tax foreclosure notice requirements. Senate Bill 819 updates notice requirements that apply when a county or municipal corporation files a complaint for judicial rem tax foreclosure on certain vacant and abandoned properties. Under current law, local jurisdictions must send notice of first-class and certified mail when initiating a judicial foreclosure action. The bill replaces the current mail-based notice requirement with formal service of process in accordance with Maryland rules, strengthening procedural compliance and ensuring consistency with civil litigation standards. By aligning the notice requirement with standard civil litigation procedures, Senate Bill 819 strengthens procedural compliance, enhances legal clarity, and ensures consistency across courts and jurisdictions. At the same time, it preserves due process protections and maintains the opportunity for property owners to cure delinquent taxes before judgment is entered. Senate Bill 819 aims to reduce administrative burden on counties and municipalities while providing clearer statutory guidance to the courts. Most importantly, this legislation supports neighborhood revitalization efforts by improving process for addressing vacant and unsafe properties and promoting the redevelopment of productive use of abandoned properties. I notice, colleagues, that this bill is favorable by everyone who submitted testimony. There's no opposition, no fiscal note. And so with that, I hope that this committee will see fit to move this bill favorable. And so for those reasons, I respectfully request a favorable report in support of Senate Bill 819. Thank you, good brother. Absolutely. Thank you so much, Mr. Chair. Joe?
Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the committee. Nina Themlis, Director of Government Relations for Mayor Scott in Baltimore City, here to testify in support of Senate Bill 819. This piece of legislation is one of the mayor's legislative priorities for the 2026 session. It does one simple thing. It replaces the 5-day mailing notice requirement with a reference to the Maryland rules, which currently has that same 5-day notice mailing requirement. The reason that we'd like to do this is twofold. The first of which is several sessions ago, the legislature passed a piece of legislation that created in rem 2 or a subsequent type of in rem foreclosure. And in that legislation, it refers to Maryland rules and doesn't specify the 5-day mailing notice requirement. So we just want to make sure that there's consistency between in rem 1 and in rem 2. The second of which is that Maryland rules may change over time, and we don't want for there to ever be any disagreement between what's required for in rem 1 and what's required for in rem 2. The in rem foreclosure process is one of the tools in the toolbox that Baltimore City uses as a part of its larger vacant reduction strategy. And I just want to highlight that over the past 5 years, we have brought a vacant housing number that was at 16,000 or above for about 20 years. And just as of yesterday, there are 11,990 vacant properties in the city. So a huge reduction action in that short period of time. And so in REM 1, in REM 2, all the other pieces of legislation that this General Assembly has passed and funding that we've received have helped us to move that number down to where it is today. So for those reasons, request a favorable report on Senate Bill 819. We'll turn it over to Joe Kirshner from City DHCD.
Good afternoon, Mr. Chair, committee. My name is Joseph Kirshner, and I am the Assistant Commissioner for the Development Division Legal Section in DHCD, Baltimore City's DHCD. So our jurisdiction has really made great use of judicial in rem foreclosure. To date, we filed over 1,000 cases. We've completed, the numbers are changing fast on us, but we've completed roughly 750 acquisitions this way. There's a lot of process. There's a lot of notice process in our current system. Before we can file a case, we have to send notice 30 days before to the owner by certified restricted return receipt mail. There's post-filing 5-day mail requirement, which is the subject of this. We have to post notice on the property. We get court summons and serve process on each defendant, which can be up to 3 certified restricted return receipt mailings. And we publish in a local paper for 3 consecutive weeks. So we're always trying to find ways to be more efficient. And this change would allow us to look at the Maryland rules, to look at the city code, make some adjustments without having to come back here. So that's what we're trying to accomplish. We're always aware of due process rights of all the parties. We wouldn't make any changes that would end up with us not having good title. But this will help. Thank you. Happy to answer any questions.
Bringing in the rear.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Odette Ramos. I'm the City Councilwoman for Baltimore City's 14th District. The in rem foreclosure legislation was first passed in this body in 2018 and 2019. I was not a council person at the time, but the lead advocate when I was at the Community Development Network of Maryland. Senator Eckert was the sponsor in the Senate, and it came before B&T. So I want to just take a second to explain to this committee, because it's a different committee that it's coming into this time, what we're talking about. In rem foreclosure is when the liens exceed the value of a vacant lot or a vacant property that the jurisdiction can foreclose. It is a faster process than what we've ever had. This bill was a statewide bill for a reason, so that every jurisdiction could take advantage of it. Baltimore City is the first to implement it. And so when I became a council person shortly after that, worked with the administration to implement it in Baltimore City. As you heard, we've already acquired several hundred properties that we can then work with our partners in communities to be able to get them to productive use for our communities. And so as we've had this practice for the last 3.5 years, we've seen where we need to make some efficiencies, and that's why we're here, just to be able to make those notice requirements consistent and that way, and we're keeping everything else that makes NREM great, which is the lots of notice, so everybody in the title knows what's happening, and we can foreclose on those properties and make sure that everybody gets a chance to have amazing, livable, safe, and communities. So, you know, again, this is new for this committee, but I do hope that you'll support us in this, and I encourage every jurisdiction in Maryland to utilize this tool. It is an amazing tool, and look forward to continuing the discussion with all of you, and thank you very much for your time. I have a lot of practice.
No worries. You were actually not timed because you're an elected official, so sorry, apologies for that, but you landed the plane on time, so it's good. Well, since this is the sponsor panel, we're going to open it up for questions. Senator James has a question.
Oh, Councilwoman, what was your name again?
Odette Ramos,
Thank you so much for coming. I was not here in 2018 or 19, but even if I had been, I don't know if I would have been on B&T. So very, very helpful. So I just want to understand one thing. and any of you can answer this, but perhaps you would like to go first. So this is wonderful for Baltimore City. A lot of vacant properties are very challenging no matter where you are, and it just brings down the neighborhood. So what are you finding? Are you finding these whoever owned the property, have they forgotten about it, or are they kind of those absentee landlord types that are, slumlords or whatever, that kind of thing? I mean, what's the predominant thing? And then how popular is it for you to get those properties, rehab them, and get them back out and in use? And improving community.
Yeah, no, I appreciate that question, if you don't mind. In terms of your first question, there are sort of 4 reasons that we have vacant and abandoned properties. One is people have died, and the family is just either decided that this isn't something that they wanted to take on, or there weren't any heirs, or whatever. The other is that it may be owned by an LLC that is defunct and has been holding onto the property but then never did anything with it. We have a lot of those.
Okay.
Another reason is that there might be LLCs just holding them and actively not doing anything about them. So we want to take care of that. And then lastly are what we call zombie properties, where somebody may have thought that we were going to foreclose, that the tax sale was going to, or a mortgage foreclosure was going to affect the property, and so the family left thinking that the tax sale or the mortgage foreclosure was going to take the property.
And I'm going to let you finish, but the reason I asked is that you said the state should, other jurisdictions should look. So I wanted to know what the problems are that this addressed, so I can talk to my county. We do have problems up there. I don't know if they fit into this. So then just finish the last.
Sure. So just to add to that point, one of the reasons we went to Senator Eckert at the time that we introduced this, when I was not in the council, and I was as the advocacy, was because Cambridge was having similar issues. Okay, and she wanted to bring this tool forward. We had Delegate Holmes on the House side at the time, but Baltimore City really, took this on and said this is something that we want to do to make sure that we're implementing it first. We have the largest, challenges, and that's why we did it. Could you repeat your second question? I'm sorry.
How successful are you in getting, because that's great you got them, but now you don't want them to be vacant.
No, and so the city is actually doing a couple of things. One is that we're working with communities on what the best outcome is going to be. So trying to get blocks, and you may have heard in the news the block by block strategy. So looking at not just one-off selling every single one, but looking at how can we make a major impact in a community by getting an entire block. And I'll give you an example. In my district, the 1600 block of Gorsuch Avenue, and I'm sure the senator has some examples in his, I know he's got some examples in his district, where we know that all those properties are in-rem eligible, and we can get those. The city acquired the 1600 block of Gorsuch Avenue, the entire block, within a year, which is like lightning speed. I might be exaggerating slightly, maybe a year and a couple months, but that way we're working with a partner of the community to be able to rehab the entire block, and so that makes a difference for the entire community.
Of course,
so some of them, some of them we're holding to have that strategy. Some of them are posted on and bid on, and people can then buy them. So it really kind of depends on the outcomes that we want in each neighborhood.
But I really like that you're saying you take a global strategic approach.
That's correct.
And just because something's available, you have limited money. You say, okay, that's true, but strategically we can get more bang for the
That's exactly right. And that way we have economies of scale if we're working on a whole block rather than here, 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 and here. But also it has maximum impact for the community. And the most important thing is that we're working with the community on what their outcomes to be, right? We're not just saying any developer can come and do whatever they want. We're being very clear and strategic about those outcomes. So even though we want to be quick about this, and INREM helps us with that, we do want to be strategic in the disposition.
Thank you very much.
Sure. Yeah, great question. I'm glad to be able to do that.
Yes, very helpful to me. Thank you.
Absolutely.
Further questions from the committee? All right. Thank you very much, Councilwoman.
Thank you. Thank you so much.
Thank you all. Excellent. All right. Well, also, so we've had someone else, one more additional witness signed up in favor, which is Claudia Wilson Rendell. Welcome.
Good afternoon. My name is Claudia Wilson Randall, and I'm the current Executive Director of the Community Development Network of Maryland. And I'm happy to be here today to speak in strong support of the bill, Senate Bill 819. I think the previous panel really summed it up nicely. This has been a really effective tool in Baltimore City for addressing vacant properties. As the statewide organization in advocacy, I'd love to see more organizations take this on. I think I also want to say that when we first proposed this idea as advocates and did some research around this, the first answer was no from everyone. So I'm really excited to see Baltimore consider this bill, Senate Bill 819, a priority. Happy to see the Councilwoman Ramos here speaking in favor of the bill. And just going to wrap it up there. Thank you so much. I urge your favorable report for Senate Bill 819.
Oh, I'm sorry. No. Glad to see you, though.
Hey, no worries. Just want to make sure. All right. Hey, well, thank you very much. All right. With that, that'll conclude the hearing for Senate Bill 819. We'll now move on to Senator Henson with Senate Bill, let's go 650, 651. Which one? Let's roll with it. So, got it now. All right.
May I bring up the panel?
Yes.
I believe on Senate Bill 650, we have a few folks. Yes, thank you. This is 650, no before they knock.
Oh, I'm sorry. So this is Senate Bill 650.
Here we have. Thank you. Yes, we are. Thank you, Mr. Chairman, Vice Chairman, and colleagues. For the record, I'm Senator Shanika Henson, here on Senate Bill 650, Family Law, Child Abuse and Neglect Investigations, Know Before They Knock, Family Right to Notice Act. What this bill does is several key things. It takes what's already existing in our family law code in terms of a parent's right if they're under a Child Protective Services investigation, and it would put those rights into a Bill of Rights or information that would be shared with the parent at the outset of an investigation. I'd like to just, for the humanizing context, share some scenarios in which this bill might come into play. Let's imagine that you are a new mom postpartum in your childbirth and delivery, and you get a knock on the door one day. That knock is from someone who looks and appears very official, and that person tells you that there is an investigation, and if you don't let them in, if you don't allow them to question you about your child and about yourself, that your new baby may be taken away from you. Now, if you're that parent and you're in that position and that happens, you can imagine how all of the things that are happening to you physically, mentally, you having someone who looks very official that appears at your door and doesn't tell you any of the rights that they have, but tells you all of the authorities that they have, how that could create a power imbalance in a situation in which a person doesn't make the best decision for themselves. I'll give you another scenario. Let's say you're a teacher and you're a mandatory reporter and you notice a bruise on one of your students. You don't have to make assumptions about where that came from, but what you know is that it's your responsibility to make a mandatory report. Let's say that bruise actually came from a soccer game that the kid was involved in over the weekend, but you see it, you make the report nevertheless. You're a parent, you get contacted by someone who, again, appears very official, and that person tells you that they're there to ask you some questions about the bruise that's on your child. If you're a parent and you're very nervous by that engagement with the person, and you make some inconsistent statements before you get the opportunity to explain that that bruise came from the soccer game, not from anything that was foul or anything that was an abuse or neglect of that child, then those inconsistent statements could be used to draw you into a protracted and prolonged process where now you are the subject of an investigation. My final scenario, if you are a person and English is not your first language and someone knocks on the door to say, hey, I'm here to investigate a report of child abuse against your child, and you wanting to cooperate with the person on the other side of the door, let that person in, and then they, in very official speak, tell you what they're there for, and the person with limited English proficiency nods as the person is speaking to them out of politeness and a desire to move the process along, and then signs a formal agreement obligating themselves and making certain omissions, but not really understanding the process that they're engaged in. Those are scenarios in which this bill would come into play. Because what it does is it would put into our statute that those rights that already exist, the parent would be, or the legal guardian would be advised of those rights. What the rights are is that the parent or legal guardian is not required to allow the employee into their home, because in all of those scenarios, it is not a police officer that's there, it is an employee of the Department of Human Services. If it were a police officer and it was a criminal investigation, it would be a whole different matter, which ironically would have some rights attached to it, where you would be advised of your rights at a certain point in that process, which does not parallel or exist in the DSS process. But they would be advised that they don't have to let that parent in, that person in, that employee. Now, if there were a court order giving them access to the child, or if there was an emergency circumstance where that person came with a police officer, then they would have to. But absent those circumstances, they would be told they don't have to let the person in. The parent or legal guardian would also be informed of the allegations against them. Sometimes the questioning starts, people are put in a position where they feel like they're compelled to respond, and they don't even know what they're there to investigate. If it was the bruise that was saw on the child that came from soccer, the parent might right away say, we were at a soccer game and that bruise came from the soccer game. But if you're not even advised of the allegations, how would you know how to begin or where to answer those questions? Third, the person would be advised as well that they have the right to consult an attorney, because there are times where parents don't know that and aren't advised of that. Fourth, the legal guardian or parent would be advised of the fact that they are not required to allow the employee of the Department of Social Services to interview or examine the child unless the interview or examination is ordered by the court. So they would be told that they are not required to do so, but they certainly could consent. If the parent says, I just want to get this over with, I know this is false, they certainly can consent, but they would be on notice that that consent is knowing, intelligent, and voluntary, because they would know they're not required to. Fifth, the parent or legal guardian would be notified that unless there is a court order, they do not have to agree to any requests made by the employee of the Department of Social Services. That could include taking a drug test, an alcohol exam, or submitting to a mental health evaluation. Also, the parent would be advised that any statement made by the parent or legal guardian could be used in a future court proceeding or administrative proceeding. They would also be advised that an employee of the Department of Human Services is not an attorney and may not provide them legal advice. You can imagine in the course of a conversation concerning one's child that when a person knocks on your door and appears as an authority figure, you might ask that person a few questions back when they ask you some questions. Well, it would be important for them to know that any statements made by that person is not legal advice, and that wouldn't be clear unless someone told you that their statements don't amount to legal advice. The parent would also be, or guardian would be notified that they are not required to sign any documents presented to them by the employee. They would be notified that the exercise of any of these rights described in the paragraph, and this is important, including the right to refuse to speak with the employee, the right to deny entry into the home, that yes, you have those rights, but those rights also have corresponding consequences. And if you don't cooperate as they have been given the right to, or to decline, that it would open the door for that employee to file a petition for removal of the child from the home. So some of the opposition testimony that you'll hear will be couched in the terms of if people are advised of their rights, then automatically they won't participate anymore. I don't know if any of you are A&E watchers. My husband's favorite TV show is The First 48. And if you've ever seen it, you understand that people are advised of their right in a criminal context, but that show exists because there is a plethora of people who, after being advised of their rights, even with criminal liability, they still choose to participate in an investigation. Certainly in this bill, a person would be advised of their rights to decline participation, but also advised of what the potential consequences would be if they do decline to participate in the investigation. So it is not a blanket persuasion to not participate. It is a fully informing and empowering of that parent or legal guardian with the information and the rights that already exist in the law and the information about what happens if they choose to move forward or not in participating in the investigation. And that is the bill that's before you today. With that, Mr. Chairman and colleagues, I will ask for a favorable report on this, and I will turn it over to the panel. Thank you.
Mr. Chair, Mr. Vice Chair, and members of the committee, again, I'm Nina Villamar, Chief of the Parental Defense Division at the Public Defender's Office. Our division represents parents in all 24 jurisdictions in Maryland whose children have been removed from their care or are at risk of having their children removed through a process called the Child in Need of Assistance, or CINA, case. A CINA case is the legal process through which the state can remove children from their parents and place them in foster care. Sometimes parents lose custody of their children forever. Most of these cases begin the same way, with a knock on the door from Child Protective Services. Under Maryland regulations, CPS has to investigate any report that is screened in for suspected abuse or neglect based on reasonable suspicion alone. That investigation typically begins with a home visit. During that home visit, CPS may enter and search the family's home, interview the children separately from the parents, visually inspect the children's bodies, and ask parents to sign documents like custody agreements, sometimes placing children outside of their parents' custody without any court oversight. And yet, under current law, CPS is not required to inform parents of their legal rights during the investigation, rights like the right to consult with an attorney or to refuse to allow a stranger into their home without a court order in a non-emergency situation, or the right to decline to sign a document that could result in custody of their child being given to someone else. But parents don't know about these rights because under current law, CPS doesn't have to tell them. I'd like to offer a simple comparison. If I steal a $6 pair of socks and the police comes to my house to investigate, I must be informed that I have the right to remain silent and the right to an attorney. But if someone accuses me of neglecting my children and the state comes to my home to investigate and has the authority to take my child away, I'm not entitled to be informed of my rights. May I finish my thought?
If you could conclude your
Yes, I
testimony,
will.
please.
In the
Thank
sock example, the worst case outcome is a misdemeanor, but in the child welfare context, the outcome can be the separation of my children from me, sometimes forever. The only reason to oppose this bill is to keep families in the dark.
I appreciate it.
Thank you.
Whomever would like to go next.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Haley Lichterman, and I'm the Deputy Chief of the Parental Defense Division at the Maryland Office of the Public Defender, and I urge a favorable report of Senate Bill 650. I come before you with a perspective honed by 14 years of working in the child welfare system. I spent the first 7 years of my career representing children and the last 7 years representing parents. This vantage point has taught me that a child's safety and a family's constitutional right are not in competition. My time in the trenches has shown me that when we protect procedural integrity of the parent, we are directly protecting the stability and well-being of children. In my experience, the interests of the child are inextricably linked to the rights of the parent. A child's primary need is a stable and secure home. When the state relies on confusion or intimidation to enter a home, it creates a traumatic invasion that the child absorbs. Transparency is a trauma-informed best practice. We should never be afraid of a family knowing the law. A system that relies on parents' ignorance of their rights is a system that undermines public trust and exacerbates disparate outcomes on our most vulnerable communities. I want to speak directly to the department's fiscal note, which assumes that informing parents of their rights will create an administrative burden and a surge in court filings. The data of our pre-petition Better Together program, where parents are informed of their rights and provided with an attorney, proves that assumption is wrong. In fiscal year 2026, we saw only 8 court filings out of 63 cases. And in this fiscal year, that's been improved with 3 filings out of 42 cases. This 93% diversion rate demonstrates that transparency is not a burden. It is the ultimate tool of judicial efficiency. When families understand the process from the first knock and cooperate voluntarily, it keeps them out of the courtroom. SB 650 does not change the state's ability to help a child in an emergency. Maryland Family Law Article 5-709 already gives the state the authority to go in when a child is in substantial or imminent danger. And for that reason, I would ask that the committee issue a favorable report of Senate Bill 650.
Good afternoon, Chair Smith and members of the committee. For the record, my name is Yanetta Manuel, Public Policy Director with the ACLU of Maryland, here in support of SB 650. As you've heard, the rights outlined in this bill already exist. The problem is that many parents do not know that they have them. They often don't understand their rights during a child welfare investigation, or that exercising those rights can feel risky when the potential consequence is the removal of their child. SB 650 simply ensures that families are informed so that they can navigate the high-stakes process with clarity and fairness. This is especially important given the disparities in our child welfare system. In 2022, Black children made up 52.8% of Maryland's foster care population, despite being only 30.6% of the state's population. That same year, DSS investigated over 17,000 allegations of maltreatment. And in 71% of those cases, the allegations were unsubstantiated or ruled out entirely. National research shows that more than half of Black children will experience a CPS investigation by age 18, and Indigenous parents are 4 times more likely to have their children removed. Poverty can often be conflated with neglect, and Maryland's definitions of neglect are broad and subjective, leaving too much room for inconsistent application. While CPS investigations may be well-intentioned, the stakes for families are enormous. Informing them of their rights does not undermine the child's safety, it simply strengthens the integrity of the process. For the foregoing reasons, the ACLU of Maryland urges a favorable report. Thank you.
Excellent. Thank you very much, Senator, and to the panel. Questions from the committee. Senator James.
I chair or co-chair a committee, not a standing, called Children, Youth, and Families. And in a prior life when I was in the House of Delegates, I was a subcommittee chair for both health and human resources in this area. So based on that, I have come to know a lot of research and data that unfortunately shows that our, protecting children in Maryland and probably nationally is way insufficient, and that we have cases that overwhelm caseworkers. We've had many cases, tragic cases, where the resources were not there and things were missed and children, end up dying. Experts tell me that they're constantly getting data late and then finding out that there are horrific problems in the system in protecting children. And basically our child welfare system is not an arbiter or an equal opportunity for parents and children. We step in and our singular focus is the best interest of the child. And in this instance, basically, we're talking about we could have imminent danger to a child unknown to anyone unless there's an investigation. So the idea of having a court order sounds fine unless you realize you're in a vicious cycle where in order to even proceed, you've got to do some investigative work. So and then I've just read some of the statutes that exist that really mandate what a state is supposed to do upon a complaint or information about, a child perhaps being neglected. And maybe this is for the sponsor, and I know your heart's in the right place. I see them now, we're in absolute conflict with each other. What exists and what investigators are obliged to do, which is to promptly, I think it's like they're on a deadline, 24 hours. They have to see the child. They have to interview the child. They have mandated determinations that they have to make. They don't have actual knowledge before going in whether that child has been abused or not. What I'm worried about with this statute, I understand the issue of parents being better informed. But to me, we would be then having two statutes directly in conflict, so that would be unworkable. And we should never ask any state workers or anybody to try to, meet two different obligations that don't work well together. So maybe the sponsor would want to address that a little bit. And then I think that my second question would be, I haven't seen data. I'm aware of anecdotal cases for sure, but I don't have data en masse that parents are being overwhelmingly unfairly, accused and lose their children en masse relative to the overwhelming cases where children are missed and not protected and not taken care of. So if you have data beyond, I know the stories about how often, and a parent who has done nothing wrong at all was, I guess, unfairly from the moment that started to the end, and lost their child, and there's just no debate that everything that was wrong was done by the state and their ability to investigate quickly these kinds of cases. Because I need those kind of data to see that this would be the right solution, because I think the right solution would be perhaps not putting the state in the middle of this and what do we tell parents, but making sure we have better communication for parents, more notice for parents, and things like that, as opposed to doing it this way. But I'm delighted to listen to your answer, Senator Henson.
Thank you, and thank you for your leadership on the Joint Committee on Children, Family, and Youth. I've had the wonderful opportunity to serve on that committee while I was in the House and now in the Senate as well with your leadership as co-chair. I do appreciate that. The first of your questions, I think embedded in the question was also a really fantastic response. None of the timelines change. The period that's required for the initial investigation, the period that's required for the completion of an investigation, this bill doesn't alter any of those timelines. So our DSS workers would still be responding just as timely as they are now. To your second question about the need for data to kind of understand the full scope of the problem, we do have a report from 2023 which indicated that here there were 20,647 of these investigations of abuse or neglect against children, and that of those, 6,074 of them were found to have, the allegations were founded, which meant that 70% of those investigations resulted in no finding of abuse. So for your question about how often is it that people are confronted with this scenario where there's this power imbalance, and how often is it that it's not in fact and the allegation isn't sustained, the answer to that would be 70%.
I want you to answer all, but I want to add subset so we don't lose the thread here. So respectfully, let me ask you this. I'm very aware of, the numbers that are alleged and then the 6,000 or so that go forward. But the research I've read, that 70% do not assume that is an exoneration or a wrongful investigation. In vast majority of that 70%, it has to do, Senator, background music. That 70% should never be used to claim that all those other cases didn't warrant some investigation, or that they were resolved to the to the benefit of the parent, that they were wrongfully investigated. It is a very complex thing that goes on, and I don't think we have time here. So I just want to clarify. I'm aware of that 30 to 70, but I think everything I've read, and you're welcome to give me any report you have, I'm pretty sure that other 70% is not indicative of wrongful investigations en masse.
And I don't want to say that it is wrongful if it was investigated. It simply didn't meet the burden of proof that there was a finding of maltreatment. But whether the investigation, whatever it did reveal,
there are complex reasons why they don't.
Whatever opportunities there were for intervention or contact with the DSS system or services that may have been provided, even though the standard of maltreatment wasn't breached there.
Well,
I'm making no assumptions about what happened in those 70%.
Okay, good. All right, sorry. And then I think I cut you off I think we had a third question you were going to answer. I apologize.
If there was a third, I did not
All right,
capture
well,
it.
that's helpful. Thank you very much, Mr. Chairman.
Thank you.
All right, further questions from the committee for this panel? All right, seeing none, thank you very much, Senator.
Thank you, Mr. Chairman.
Excellent. All right, so we've got a few folks signed up in support of this bill as well. So we'll hear from Amy Vora, and that's virtual, and Christina Hawkins is virtual. Everyone else is virtual. All right. Oh, you're up. Welcome. There you go.
I apologize. Who was called? Was it?
You are. Yep. You're up.
Okay.
Welcome.
Okay, wonderful. Thank you so much. Good afternoon. My name is Ami Vora. I'm with Maryland Legal Aid. I'm the Advocacy Director for Family Law. Across Maryland, our lawyers advocate for parents in family law cases as well as represent children in SINA cases. And because of our unique perspective of how CPS investigations impact low-income families, I'm here to urge a favorable report on SB 650, a bill that strikes a really thoughtful balance between preserving the government's responsibility in protecting children from abuse while respecting the privacy and due process rights of parents. Legal Aid knows firsthand that child abuse is real and that investigation and recourse is essential. But we've also seen how low-income parents are too often subjected to unfounded CPS investigations. A very typical scenario we see is that our clients experience is when an abusive ex-partner makes a false report to CPS as retaliation or to get a leg up in a custody proceeding. Sometimes a poverty-related hardship like food insecurity or housing insecurity is mistaken as neglect, leading to CPS to show up at our clients' doors. Our clients are confused and terrified when the government knocks on their door, and they report not understanding the allegations against them, not knowing whether they can refuse entry, not knowing whether they can even consult with a lawyer. All SB 650 does in these circumstances is to require government workers to inform parents of their rights and options in that moment. Rights and options they already have but do not know about. Nothing in this bill prevents the investigation of child abuse. If a parent declines entry after being informed of their rights, DSS can still seek a court order or a warrant or even enter if the child is in immediate danger and law enforcement is present. If CPS is allowed to continue hiding the ball during these intrusive and disruptive investigations, low-income families that we serve will continue feeling targeted, powerless, and as a result, distrustful of the government institutions that we want them to rely on for help. And so for those reasons, we urge a favorable report.
Excellent. Thank you very much. All right, next we'll hear from Jessica Moranto.
Good afternoon, Chair. My family story is a stark illustration of why legislation is not just necessary, but a moral imperative for Senate Bill 650. In 2014, my life changed when I answered the door to a CPS worker and a police officer. The presence of law enforcement alone was enough to make me feel obligated, even forced to comply with their request to follow them to social services with my children. Once there, my children and I were separated and questioned. I'll hold myself accountable. My family did need support at this time, support that I'd eventually receive, but not from the department. It came from a peer recovery specialist. That day, without a proper goodbye, was the last time I'd see my children for years. Had I been informed of my rights, I would have remained silent, taken my children to their aunt's house where they would have been comfortable and safe, and consulted with an attorney before signing a service plan. For over a decade, my children were separated from their immediate family. They were committed to facilities like Shepherd Pratt, bounced around from a minimum of 5 foster homes and group homes, and in their own words, never felt accepted or loved. The feelings they share with me today about their experience are filled with separation trauma and confusion that no child should ever have to bear. In Senate court, my entire truth wasn't shared. The parts and circumstances that were shared were manipulated to serve an end that dissatisfied the department. It was never their intention to return my children home, no matter how many boxes I ticked off on their service plan. My daughter, just 2 weeks before turning 18, was cruelly dropped off on the side of her road by her foster parents. Since she's been home with us, she's been gone to prom, graduated from high school, and is currently employed and motivated to go into college in the spring. My son ran away from his adoptive home and was couch surfing for nearly a year before he asked to come home for Christmas. Currently, I'm collaborating with his legal guardian to get him placed back into school after not attending for a year. He's grateful to be home with his parents and sisters. A healthy relationship is built on mutual respect, trust, honesty, and open communication. It's a strenuous thing to rely on or cooperate with a department that has a reputation for using tactics to fit its narrative, including the omission of parental rights during the initial investigation. For this, I urge you to please have a favorable outcome for Senate Bill 650. Thank you.
Excellent. Thank you very much. All right, next we'll hear from Christina Hawkins.
Good afternoon, members of the committee. I am asking for a favorable report for Senate Bill 650. On February 23, 2018, a woman who identified herself as a CPS worker and a police officer knocked on my door. I answered the door and allowed these strangers into my home. I had no reason not to. I had been taught that police were here to protect and serve, and I have never been in trouble with the law or had contact with Child Protective Services in the past. The CPS workers said they were at my house because they had a report for suspicion of use. They did not ask me to take a drug test, nor had one been taken in the past. They looked around my house and found no risk of harm. My 3-year-old daughter was laying on a made bed in her own room in a home that I owned. The caseworker then walked outside and made a call. She came back in and said I had to sign a safety plan and agree to give custody of my child to someone else or they were taking her to foster care. I began to panic. I didn't know that I was entitled to speak with an attorney or that I had options and rights. I signed a 60-day safety plan that resulted in me being separated from my child for 3.5 years. Parents are entitled to know they have rights to get advice from an attorney before signing away custody so they understand risks involved in life-changing legal matters. The department abuses their power by not informing parents of their rights and targets individuals who wouldn't know any better. If the law was that parents needed to be informed of their rights prior to CPS entering their home on February 23, 2018, I would have been able to plan accordingly for my child in a way that didn't traumatize us. I would have been able to consult with someone and find out exactly what was about to happen in my life. Today, I have 7 years clean, 4.5 years reunified, a milestone I was told I would never achieve. And I can tell you with certainty that the day my daughter was tragically pulled from my arms was the most confusing, emotional, and traumatic day of both of our lives. Today, I work in a professional capacity to ensure others don't face the same trauma that my daughter and I once had to. For these reasons, I'm requesting the committee issue a favorable report for Senate Bill 650. Thank you.
Thank you very much, Ms. Hawkins. Next, we'll hear from Shanta Trivedi.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Shanta Trivedi, and I teach and I write about the child welfare system, and I'm the faculty director of the Meyerhoff Center for Families, Children, and the Courts at the University of Baltimore School of Law. I've also represented parents who have had their children removed without knowing their rights, and I urge a favorable report. Ms. Villamar gave you an overview of what an investigation looks like, but I want you to envision yourself as the subject of this investigation. CPS knocks on your door in the middle of the night and they say that they're going to search your home. They will look in your medicine cabinet, your bedroom, your refrigerator. They'll ask you questions about your romantic partners. They'll ask to speak to your children without you being present and will inspect their naked bodies for bruises, regardless of whether the allegation against you involves physical abuse. Before completing their investigation, they may even tell you that you have to transfer custody of your children to someone else or risk them being placed into the foster system. How would you respond? Would you know what to do? Would you want to speak to a lawyer? Most people do not know what to do in this situation, particularly if they are economically or otherwise disadvantaged. And many of those who oppose the bill say that it would create new rights, and that simply is not true. Even the department acknowledges that in their fiscal note, and this bill would just inform families of the constitutional protections that already exist. To date, Connecticut, Texas, Florida, Montana, and Arizona have all passed these laws. And New York and Delaware have introduced similar legislation. The question is whether we want to join those states in respecting constitutional rights for all parents, or just for the privileged few. Rather than making children less safe, the states that have passed similar laws have found that they keep children safer, because transparency from the agency encourages families to be more forthcoming. Further, the law already provides for law enforcement and DHS to be able to enter in emergency situations. DHS also has the authority to speak to children at school, in the rare situation that a parent refuses to give them access to the child. This bill would not change those things. I know that opponents do not want DHS to be perceived as a policing agency, but unfortunately they already are. A fair and just society requires that people know their rights. It is the bare minimum, and I urge you to support this bill.
Excellent. Thank you very much. All right. Are there questions from the committee for the panel joining us virtually? All right. Seeing none, thank you all very much. So that'll conclude the testimony for the proponents of the bill. We'll now switch to the panel signed up in opposition. We'll hear from Edward Gallo. Allison Alessandro, Wendy Lane, Jennifer Stein.
Chair, pardon me. I did sign up to testify. I'm Stephanie Franklin for favorable with amendments.
Let me see.
And I also submitted written testimony. Yeah, I signed up on the MD. I did.
Well, I somehow don't have, do you have it? We don't have a record of that. Since you're, we'll allow you to go ahead and testify. You're favorable with amendments?
Yes.
If you could, we'll allow you to testify. Please go ahead and then the.
Okay, so good afternoon, Chair, Vice Chair, Committee. My name is Stephanie Franklin, and I am the President and CEO of the Franklin Law Group. We have provided legal representation to children ages 0 to 21 and SENA, TPR, and related proceedings since 2007 in multiple jurisdictions across the state of Maryland. I've personally represented children for 27 years and am co-counsel in the LJV Lopez federal class action lawsuit representing all Baltimore City children and out-of-home placement for close to 5 years. There's been a mischaracterization of this bill by the sponsor and the supporters. This bill is not just about notice to parents. This bill is layered and includes denying children of their rights to be safe and well if there is a possibility of harm. As I've stated in our written testimony, the problem with this bill is the inherent tension between rights of parents and rights of children. It privileges the parents' rights over the rights of the children. It delays access to the child, the home, and the child's medical records. And while I strongly agree with the supporters of this bill about the vulnerability to Black families who have borne the brunt of removals that are rooted in a history of enslavement and subsequent oppressive policies that destroyed Black families, parents, and children. And I agree with the undeniable importance of family integrity. We can't pass a bill that denies children their rights, particularly if there is even an inkling of a possibility that the child is unsafe. However, this bill is fixable. Parents deserve the right to notice and protection of their children, and children deserve the right to be checked on to ensure they are safe and well, particularly children that are nonverbal and or disabled. Therefore, in the interest of time, I ask the committee to review my proposed modifications to this bill, which apparently you don't have. There's several, but I want to say this in closing. This legislative body has a responsibility to legislate at the margins. That is, in the light most favorable to the most vulnerable in this bill, and that is the child.
Thank you very
So for these reasons, I request this committee to issue a favorable report with amendments. So Chair, I need to ask, how would you like me to get this, my written testimony to you?
Through the normal portal process. If you go to the front office, leave your email, we will respond to you, and it's the normal portal process that you signed up through. So go around the front and we'll get you straight.
Okay, thank you for the accommodation. Thank you for your time.
Appreciate that. Thank you. All right. The opposition panel. Whoever would like to come up first.
Okay, sure. I'm standing.
There you go.
Good afternoon, Chair, Vice Chair, members of the committee. Thank you for the opportunity. I am Jennifer Stein. I'm the Executive Director for the CASA program in Baltimore County. CASA stands for Court Appointed Special Advocates. We are a nonprofit that supports the best interests of children in foster care. I'm also a mother. As Ms. Franklin said, I also agree with this bill. I think that parents should absolutely know their rights and be able to exercise them in any situation. And Section E that's been added to this portion of the law is very important. However, I believe strongly that one small part of it, Section E14, puts children at risk. And unfortunately, because we've not been able to come up with agreed upon amendments, I must oppose the bill. Most initial interactions with CPS are not involving police. Police typically only come when a second round is needed because something else has happened after a first interaction. Most are akin to welfare checks. There's no naked exams, no removals. Most of it is a conversation in that first interaction. Many of those become alternative response, simply where services are provided. If a worker is unable to see a child and make a true assessment of that child's safety, I have serious concerns that we will end up with either significantly more unnecessary removals because the worker will simply be afraid that if they leave the child there, something will happen, or not enough removals when there is a serious situation, but the worker is unable to determine that. And they don't always know that unless they are able to see that child. So for all of these reasons, I, again, support the intent of the bill for parents to know their rights, but have to oppose the bill in its current form and request an unfavorable report. Thank you.
Chair, members of the committee, good afternoon. My name is Allison D'Alessandro, and I've worked in the field of child abuse prevention for nearly 25 years. I now work at LifeBridge Health Center for Hope, which is formerly the Baltimore Child Abuse Center. Center for Hope works every day with children and families impacted by abuse, neglect, exploitation, and violence. We partner closely with child advocacy centers, healthcare providers, law enforcement, and child protective services to ensure that children at risk receive timely, trauma-informed, and coordinated intervention. For these reasons, we oppose Senate Bill 650. While we absolutely support parents understanding their rights, this bill risks putting children in harm's way. In practice, this will function as an invitation to refuse cooperation at the earliest and most critical stage of an investigation. As written, it tells parents they are not required to allow investigators to interview, or even see their child unless a court orders it. Again, this bill permits parents or legal guardians to refuse to let CPS talk to or look at a child when timing is crucial. Even short delays can significantly increase risk. Nationally, nearly 2,000 children die each year from abuse and neglect, many of them infants and toddlers who cannot speak for themselves. Caseworkers must be able to see children promptly to determine whether they're safe. This bill shifts the balance away from child safety and toward adult procedural rights. It risks more adversarial investigations, more emergency court involvement, and even unnecessary removal simply because investigators cannot promptly assess a child's safety. Children are individuals with their own rights and their own voices. Any change to child protection law must begin with one principle: the child's safety comes first. For these reasons, we respectfully urge an unfavorable report on Senate Bill 650. Thank you.
Good afternoon, Chairman Smith and members of the committee. My name is Wendy Lane. I am here representing the Maryland chapter of the American Academy of Pediatrics. We are a statewide association representing more than 1,100 pediatricians and allied pediatric healthcare practitioners. MDAAP is a strong and established advocate promoting the health and safety of all the children we serve. On behalf of MDAAP, we voice our strong opposition to SB 650. Let me start by saying that MDAAP supports letting everybody know their rights. Our concern is that the language of the written notice establishes an adversarial relationship that's focused solely on the rights of the parent while ignoring the rights of the child. Such adversarial language will instill fear in parents and increase the likelihood that they will refuse access, assuming that refusal will protect their family. In truth, this refusal may harm their child. As a pediatrician, I've seen too many children brought to medical care or to the medical examiner's office with severe abusive injuries, malnourishment, and neglect that might have been prevented or ameliorated had DSS been able to see the child, connect the caregiver with services, and gotten the child to medical care. All children deserve to live in a safe and protective environment. No child wants to be beaten, burned, locked in their room, or denied nourishment. Allowing them to be seen and to tell their own story can stop the maltreatment and increase their safety. SB 650 strips children of their right to safety and protection, and Maryland children deserve better. I urge an unfavorable report. Thank you.
Before we hear from our next witness, if you are a page, especially if you're from District 20, you're welcome to come up on the side here and watch the proceedings from here. But all right, all the pages are, yes, please, welcome. Obviously, you can just come up there. All right, thank you, sir. Thank you for that.
Good afternoon, Chair Smith and members of the committee. My name is Ted Gallo. I'm the Executive Director of the State Council on Child Abuse and Neglect, otherwise known as SCAN. SCAN is an advisory body required by Maryland Family Law Article to make recommendations annually to the Governor and General Assembly on matters relating to the prevention, detection, prosecution, and treatment of child abuse and neglect, including policy and training needs. SCAN supports the concept of transparency and parents knowing what their rights are. However, this bill fundamentally inverts the priority of our child welfare system by placing procedural rights of adults above a child's fundamental rights to safety and protection. Proponents claim that neglect is just poverty misunderstood and that these warnings won't cause delays. But neglect is the leading cause of death and the child fatalities in the state of Maryland. Just 24 hours can be the difference between a child receiving medical care and ending up in the medical examiner's office. If we want to look at other states as models, in 2011, Connecticut passed a nearly identical parental rights law. 3 years following, child fatalities rose 45%. One high-profile death occurred, which was caused because parents continually invoked their right to refuse and denied entry to investigators on multiple occasions. That law needed to be narrowed in 2018. Maryland should not repeat that mistake that other states have already had to correct. Finally, this bill will actually increase removals. If a caseworker is legally blocked from seeing a child, they cannot prove that that child is safe. They will be forced to return with a police escort and a court order to forcibly remove that child, a result that is far more traumatic for the family than a standard social worker visit. I speak to you not only as the Executive Director of SCAN, but as a former Child Protective Services investigator with over 15 years of experience conducting over 2,000 investigations myself. I know exactly what happens when we knock on those doors. So with that being said, I urge an unfavorable report.
Thank the whole panel. You were far more articulate than I was about what I have witnessed and read about in the many years that I've been looking at this. And I have nothing but huge respect for the sponsor of the bill, but I feel like it was written by public defenders and not people that were trying to figure out how to, provide notice as opposed to a better angle in a litigation. So and thank you very much to the gentleman who mentioned Connecticut, because 3 or 4 states were referenced. If you would share that with the committee chair and me, a little bit of information. I can probably find it, sir. I don't want to make you talk. I just wanted to thank you because that's really important to know. We were told 3 or 4 states have done this. Maybe they have, but they might have lived to regret it. But here's my big question to all of you. I do think that it is understandable, and this is true across the board, this not just in these kind of cases, but obviously when investigations are going on, and I'm excluding law enforcement, that people with less education, I don't think being poor means that you're not intelligent. I don't like that implication at all. But assuming that you have some a lack of education, yes, are very, very smart poor people, and that's a good thing. How do we make sure we're not going to create schizophrenia, which is the wrong use of the term, for the department. This is not the way to do this, right? But what are your suggestions on how we can improve that, and should we legislate it? And I say that because this department for decades will tell you many, many things they're going to do. They have lots of aspirations that are unmet to this day. Something like this will, wouldn't even rate in the top 100. So how could we, get better communication, mandate it perhaps, force it? How would we do that with short of a bill like this, which I just think is unworkable for all the reasons you all have stated, and also changes the risk calculation too heavily against the child?
Can you hear me?
Is it on?
Sorry.
Oh, that's right. Yeah, sorry, I forgot.
Sorry, I'm in the wrong building. I think I have a couple of thoughts. I know that certainly for this particular bill and trying to make it workable, like I said, we have offered some amendments that felt better to the various people that have spoken so far in order to be able to ensure children's safety while also informing parents of their rights. So if we do, sorry, do you want me to wait? I can wait.
I can't.
That's fine.
Too much. No, I want you all to come up, but if you could go this way.
Pages can also come on the other side here.
Yeah,
as well.
I got to.
Yeah.
Sorry.
Come on the other side.
I'm sorry.
You're
Go ahead.
That's okay.
Your organization is which one now?
So my organization is CASA of Baltimore County, Court-Appointed Special Advocates. I also serve on the Coalition to Protect Maryland's Children.
I'm well aware of CASA. I just want to make sure I have. So when I locate your testimony, it doesn't matter right now.
Sure.
I will find that you have some language or amendment, and I'm asking whether or not we should, do a different bill that is there a way to amend this bill, and turn it into, because sometimes when you try to revise something, it's not as good as if you just start clean.
Sure.
And
so I am not an expert in legislation, and so I don't know that I can necessarily.
I'm so glad somebody in this room has humility.
So I don't know that I can necessarily say the best way to do a bill, one way or the other, but I do think that we did work very hard and now I'm speaking the Coalition to Protect Maryland's Children, did work very hard to come up with some amendments that we felt did both, right? That allowed for parents to be provided documented rights. There was even conversation with the parent about their rights to make sure that they understood. We are open to talking through those things, but we also want to make sure that children's safety is not forgotten.
I didn't mean to put anybody in the spot.
No,
Listen,
that's okay.
The hearing is becoming too long.
Sorry.
And I love to have conversations, and I'm not the chairman of this committee.
I'm happy to speak with you
I got to
later
keep the
if you
pace
want.
going before I get gavelled down.
Sure.
So I would just say to you all, I'm very interested in the issue, but I'm very, very, very interested in not changing the equation and the law for protecting children, which we do not do adequately now. Nothing can change, nothing can make a bad situation worse, and I think this would be a part of that unwittingly. So just follow up.
Absolutely.
I'm interested in the subject.
And you're going to hear
also
from
children need their
Diana.
families.
I'm sorry, you're going to hear from Diana Phillip also, who is with the coalition, and she's better at the legislative answers than I am.
Yeah, I didn't mean to put you on the spot.
No,
All right.
that's okay. Thank you.
Mr. Chairman.
Thank you. The gentleman from, is it Stand? Scan? Thank you. You said you used to do this. Was it in the state of Maryland?
Yes, I spent, actually it's a little over 15 years. Most of that was in Anne Arundel County here, but some of that was also on the Eastern Shore.
So can you walk me through, you come to my house, there's been some complaint. What happens? I'm the parent.
Well, the first thing I would do is introduce myself, why I was there exactly, explain that I need to get to the bottom of it, find out if the allegations are in fact true, ask for permission to see the child. And there's a lot of variables that go into that, but generally speaking, that would be how it's conducted. You try to see the child and ideally talk to the child alone.
And during the course of that process, do you let the parent know what their rights are?
During the initial time that I would meet the parent face-to-face, then I would explain to them, there's actually a brochure that we're required to give the parents and have them sign acknowledging that they have received, and in that brochure.
And that brochure, it has the rights all laid out?
I don't want to speak to that. It gets amended every few years. I haven't seen the most recent one.
And that's given to the parent upon your introduction of yourself?
Yeah, it's usually given during the initial home visit at some point. It's not, I don't lead with that.
Is there a question of whether or not the parent then understands what's in the written materials?
No, I don't recall ever asking if they understand, if they have the ability to read.
And I'm not saying do they have an ability to read, do they have the ability to understand?
Right.
Reading and understanding is not the same.
Very true, very true.
And I'm assuming this documentation is written in a variety of languages then?
It's written in English and there's one in Spanish. Those are the only ones that I'm aware of. I've heard Montgomery County has it in other languages, but I've never seen that.
If a parent, if you come to my house and I say, no, you're not going to see my child, what would happen next?
Well, depending on the severity of the allegations, if we're worried about, let's say, an infant with broken bones, then we're going to show up with the police and insist that the child be seen. If we're talking about a 17-year-old who's done something and the allegations aren't particularly serious, maybe we'll work with the parent, make a call, try and find an amicable place and time to meet up. A lot goes into that.
So if the circumstances prove to sound dangerous enough, you're going to automatically show law enforcement anyhow, right?
If the allegations are severe enough, yes.
And I'm assuming, and I appreciate this because I'm assuming if you show up with a law enforcement officer, do they have a warrant or anything at this point, or are they just kind of showing up to be I mean, why is the law enforcement officer there with you? I'll ask it that way.
Because it's, I can't speak to the legal reason behind that, but in the code, as I understand it, that the CPS worker is required to assess the safety of the child. And if mom and dad aren't complying, then reasonable efforts are allowed to see the child.
Does the law enforcement officer have a warrant to enter the house? If they
No, they do usually, no.
Okay, thank you.
Thank you, Mr. Chair. If you would remain at the podium. So during the presentation in favor of the bill, there were a number of representatives of the Office of Public Defender, and they assured us that if you, the investigator, were denied access, that you could easily and quickly get a court order letting you in. So I think I understand from your presentation, the presentation of this panel, that it's not quite so easy or quick as the Office of Public Defender would have us believe. So would you take us through, if you're denied access to a home, and because you feel that there's an endangered child inside, how do you get access to the home? How long does it take, and how easy is it to get access?
It could take a couple of days in some situations, because we need to reach out to our legal counsel, who would then need to petition the court, and then the court needs to hear the case, and the court needs to agree favorably that the allegations are severe enough. Then we need to go into the house. Then we need to present ourselves to the house. Hopefully the parents are home and haven't fled, and then let them know that we have a court order to see the child.
And I think, was it you or someone said that, was it New Jersey or Connecticut where a similar law had been enacted? There was a 40% increase in, can you relate that statistic a second time? I missed it.
It was 3 years later, they found that they had a 45% increase in child fatalities.
Oh, wow. Okay, thanks.
Thank you, Mr. Chairman. Mr. Gallo, if I may. You mentioned in your testimony that the #1 leading cause of death for children was neglect.
Correct.
I'm just looking at the Maryland Child Fatality Review Committee, their report, and what they indicate as the #1 leading cause is accidental injury for children, and then they have the second for children a year or under as sudden infant death. So the report that you have that indicates that neglect is the leading cause, would you share that with us offline?
Yeah, sure. I believe, yeah, I'll share that offline.
Thank you.
Yeah.
And then my second question, my colleague did ask you about children who were endangered, and he used the word endangered. So the law already provides that if there's an emergency circumstance, you can summon a police officer, and the police officer can get you entry to the home if there's an emergency, correct?
Correct.
Thank you. I appreciate it. May I, Dr. Lane?
Yes.
Please. I appreciate you being here and the perspective from the pediatricians. I think it's so valuable to the discussion because a part of what a DSS worker is able to do is similar in nature to what you as a physician might do if you're examining a child that's in your office and you're trying to figure out if that child is well and okay. So I just want to be clear. The amount of training that a physician has in order to do that, could you give the committee a variety of the training that it takes for you to examine a child and make those sort of determinations?
Sure. So so as a pediatrician, I completed 4 years of medical school, 3 years of general pediatrics residency, and then I also completed another year of a child abuse fellowship.
I appreciate that. May I ask you a second question? Sure. If a parent came to your practice and they were seeking care or treatment for their child, would you start by explaining to that parent what the side effects might be? Let's say it was a vaccine, or let's say it was some other procedure. Would you explain to that parent in full what the side effects, consequences, if they did or didn't seek care? Would you have an informed discussion with that parent?
So typically a parent is coming to my practice for medical care, and they have a general understanding of what happens with medical care. If there is a situation where I see something that I'm concerned about, child abuse and neglect, I will have a conversation with the family that I see something that is concerning, and it's my legal obligation to make a report of child abuse and neglect. I don't start when they come into my office by telling them that if you come to my office, there's a chance that you will be reported for child abuse and neglect, because by far most children who are coming to a general pediatric office are not coming there because of concerns about abuse or neglect, and so that's not the
I appreciate
understanding.
that response. It didn't respond to my question, and if you're not able to, then just please let me know.
Can you repeat the question, please?
The question is, if a person is in your office with their child and they're seeking care, I gave the example of a vaccine, but I'm not a physician, I'm an attorney, so maybe you have better examples. But would you have an informed conversation with the parent where you tell them what those potential side effects are? Let's say the child has cold-like symptoms, and would you have a conversation with the parent about what it takes to make sure that child is safe or well, or what to look for if it gets worse or exacerbates? My question is about the sort of informing that you would do of a parent so that you can have a conversation with them where they could make decisions about the next steps of what would happen.
Yes, we always discuss the pros and cons of any treatment.
And in your experience, when you have that information with the parent and you share it, do you find that most parents say, well, now that you've told me, you know, what the information is, I'm going to decline care. I'm going to not move forward because there are risks associated with this, so I'm simply going to walk away. Does that happen more times than not?
So it doesn't happen more times than not. It happens occasionally.
I appreciate it. Thank you. Thanks, Mr. Chair.
All right, further questions for this panel from the committee? All right, seeing none, thank you all very much. Thanks. All right, we'll hear from Diana Phillip. Is Darlene Wakefield here? Lindsay Carpenter? Vanessa Galloway? Darlene, we're going to hear from the people who were here in person first, and then we'll switch over to you, okay?
Yes, thank you.
Excellent.
Good afternoon, Chair Smith, members of the committee. My name is Lindsay Carpenter. I'm Chief of the Special Victims Unit at the Frederick County State's Attorney's Office. I'm here on behalf of the Maryland State's Attorneys Association, urging an unfavorable report on Senate Bill 650. I think first and foremost, it's important to look at the purpose of the subtitle that this bill attempts to amend. If you look at 5702, the purpose of the subtitle is to protect children who have been the subject of or abuse or neglect. It further states that we're to do this by requiring prompt investigation of each reported suspected incident of abuse or neglect. Our concerns with this legislation as proposed is it will delay the department's ability to do the very job that they have been mandated to do. Furthermore, as Senator James has already pointed out, I wanted to note that the proposed legislation is actually contradictory to what is already required under 5706 in terms of what the department is mandated to do to try to assess the safety of the child and determine the allegations. And finally, I wanted to point out a third point in this piece of legislation. If you look at who is providing this notice, it's not just the CPS worker or an employee of the department. It also says, or the local law enforcement agency. I have significant concerns that we potentially have law enforcement officers advising parents of rights pursuant to CPS investigations and consequences pursuant to non-compliance with that, when rights and consequences pursuant to criminal investigations are very different. And I think that could be very confusing for a parent who's receiving that information. So for those reasons, we are urging an unfavorable report.
Good afternoon, members of the committee. My name is Vanessa Galloway, and foster care saved my life. My biological father was my grandmother's boyfriend. Yes, I am a result of rape. I was born into extreme difficult circumstances. My mother, death, had a limited education, and I grew up in a home where I was not safe, protected, nor nurtured. If a social worker had not been able to enter my home and conduct a wellness check, I truly would not know where I would be today. When I was found, I was malnourished and had several injuries. I was afraid, too young to understand what was happening, and too young to have a voice. I had not been in school yet, so that intervention changed the course of my life. Because someone was able to knock, enter, and act, I was given a chance to survive and eventually thrive. SB 650 helps ensure children like me are not left unseen, unheard, behind closed doors. I am living proof that intervention saves life, and for the reason, I respectfully request that the committee issues an unfavorable report.
Good afternoon, members of the Judicial Proceedings Committee. My name is Diana Phillip. I'm the Coalition to Protect Maryland's Children's Coordinator. We are a coalition that's been before the Maryland General Assembly since 1992. We are made up of pediatricians and lawyers and social workers, foster care providers, people that are on the front lines of the child welfare movement, trying to inform the best policy possible for kids who are in situations of maltreatment or abuse and harm. Our organization, our coalition, is actually deeply distressed about this bill. Just for you to know, as Mr. Gallo said, there already is an informational brochure that is given to each family when they do a visit. Actually, Department of Human Services, I thought, attached it to their information. However, sorry. The concern is the totality of the tone and the way that this is written in trying to influence the language of the notice. And so it looks like it is adversarial. It is framing it as if this is a criminal investigation in which there's supposed to be Miranda-similar rights. And these are the things that we want to caution you about, is that, yes, we are concerned about parents and legal guardians being confused and thinking that they don't have to cooperate, and what that will do with the delay of that initial contact and safety assessment period when someone is responding to an abuse or neglect report. That's a tight time, right? It's within 24 hours of a physical or sexual abuse allegation that the worker for the department is supposed to come and see the child and determine the safety of the child. We're concerned that people will look at the way this language has been written and determined that they don't have to do that. And for the Connecticut law, they changed the law because of a 17-year-old that did die of maltreatment because the mother said, I was told that I didn't have to legally provide you access to my child or talk to you. These are the reasons that we are concerned, and we urge for unfavorable report. Thank you.
All right, Darlene, you're up. Welcome.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. My name is Darlene Wakefield, and I've practiced in law for 34 years. I'm the founder of a law firm of 15 attorneys, which has held contracts with the state for the past 31 years to represent SINA children. We currently represent 1,185 children throughout Baltimore City, Baltimore County, Carroll, Cecil, Hartford, Howard, Prince George's, and Washington counties. I'm here in opposition to this bill because in my professional judgment, it tramples on the rights of children and presumes that children who are the subject of the investigation agree with their parents and do not want to be interviewed. It's important to recognize that Maryland is a client-directed model for children who are determined to have considered judgment. This type of representation assumes that children have a right to independent decision-making. If this legislature has determined that children have an independent voice, why are we now permitting a parent to hinder an investigation by preventing a DSS worker from talking to or even seeing the child? It is the very children who are being kept away from investigators who need to be interviewed. We also have concerns that this legislation is unnecessary. Creating or amending a statute is not always the best way to address an issue. The Office of the Public Defender already has a Better Together initiative, which they say is working well in Baltimore City. Why not replicate that, put up billboards, do PS announcements, whatever you need to do to get the information out? We don't need a law. This bill is an attempt to codify the program, but includes unnecessary language trampling on the rights of children. We also have serious concerns that next year, if this bill becomes law, the sponsors will be right back down here asking for you to pass legislation amending it that will ask for sanctions for DHS not complying with giving out brochures and information that needs to be given. As this hearing is being held, the House is considering HB 980 Kania's Law, which is a bill to protect children and strengthen foster care. This bill does the opposite and attempts to take away the rights from children. We ask that you I strongly urge you to vote an unfavorable report, and I'll be really happy to answer any questions you have.
I'm sure you'll get some. All right. Thank you very much. All right. We have one more guest who signed up to testify in person. So we've got room for one more. So let's do that, and then we'll open it up for questions. So is Susan Emfinger here?
Yes.
Thank you, members of the committee. I appreciate the opportunity to speak. I feel strongly about the issue, so thank you. I would just like to say that when I was 15, I went and got myself put into foster care. I demanded to be placed into foster care, or I would steal a car, be declared a juvenile delinquent, and then be thrown into jail, because that's how desperate my situation had become. Now, I was 15. This was after 15 years of neglect. This was after a broken rib. This was after getting beaten by a billy club. This was after going into an emergency room and telling the personnel, because there was no mandated reporting at that time, that a girl in my school had beaten me. Why? Because my mother was sitting right there. Because I have never done anything scarier than to go to the authorities and tell my mother that tell them that I was abused. I knew that if I hadn't had an intervention in a timely manner, that if I had been returned to my home, my mother would have beat the living hell out of me. And it would have been either me or her. And when you start to look at jail time as an alternative to getting beaten because you've killed your mother, that is when you start to understand the importance of a timely intervention. Had my mother had an intervention when it first started happening, and this started first memory, 3 years old, getting tied to a chair, then perhaps that would have been the impetus for my mother to actually get the help that she needed. But unless a worker can go in and investigate a child and speak with a child privately, that is never going to happen. And it strikes me as funny that we know enough to know that we shouldn't expect an abused woman to go in and talk and sit there and tell the truth to authorities when her husband is glaring at her and she knows what the after effects of that discovery will be. Why are we asking children? Why are we asking that of children? Why are we asking that of CPS workers whose sole job is to gather information when they go into a room? That's their only, I'm not saying the system is perfect. I'm not saying that children should be removed. I'm not saying that there aren't parents that are taken advantage of, but I am saying it's the children that are the most vulnerable in that room. It is not the parents. And I beg you not to pass this bill.
All right. Thank you very much. And thank you to the panel, and to, in particular, Ms. Galloway and Ms. Emfinger. Thank you for transmitting your stories and advocating. And to the pages in the room, you see you've heard compelling arguments on both sides of this issue. And so it's just that you're witnessing democracy at work. So it's a tough issue, compelling arguments on both sides, very emotional testimony. So just thank you all for the panelists. And we'll now open it up for questions. I'm going to go to Senator Henson first, and then we'll go to Senator Sidnor, and then Senator James.
Thank you, Mr. Chairman. My question is for the state's attorney. I think there is a perception with the hearing that this bill is about protecting parents. But I think if you pull up one layer further to look at due process, something that's a bedrock, fundamental to our criminal legal system, if a person is in court and they're going to waive their rights, before they waive their rights, would you make sure that they were doing so knowingly, intelligently, and voluntarily?
And yes, that would be after they're in court for that proceeding, but yes.
And if they were waiving their rights, the part of that that speaks to intelligently, what does it mean when you're intelligently waiving your rights?
That you've been made aware of them and you understand them.
And the rights that are codified into this bill are rights that already exist in law, correct?
I disagree with that, actually.
You disagree that these rights don't exist? Which, if you could parse out for me, which of them that you think, and if you're a state's attorney and prosecuting people potentially for crimes that could be related to this conduct, and you don't think they have the rights that are in this bill before they make statements, that is of particular interest to me. So please share which ones you think they don't have the right to.
Absolutely. I do not think that they have a right to interfere with an investigator's ability to investigate whether or not a crime has occurred. And when I say that, I also mean I don't believe that they have the ability to not allow the authorities to determine whether or not this child has abused or been neglected. Certainly, they have the right to not allow an unlawful search of their home. Certainly, they have a right to not speak with authorities, right? But I think to be able to not allow investigators to speak with or see a child, which has been mandated under this statute, that is what Child Protective Services is supposed to do. They're supposed to see the child and assess the safety of not only that child, but any other child in the home or that caregiver provides care for. I don't believe that they have the right to interfere with that. And that is my main.
You acknowledge that this doesn't change anything about the law as it relates to exigency. If there is an exigent circumstance, then under a different section of the code, 5-709, which is not referenced in this bill, they would still have the right, a DSS worker, to come with a police officer. And I think we heard a lot of testimony about instances where they do just that. And they would have the right to interview the child, see the child, and proceed forward if it were a criminal legal matter. You acknowledge that 5-709 is not in this bill.
I acknowledge that, but I believe 5709 is specifically regarding entry into the home. It doesn't discuss whether or not, and when I said that this statute is contradictory to what's written in here, I believe that the specific language in terms of what a parent is being told that they have the right to do is that they're being told that the local department cannot interview or examine a child unless it's ordered by a court or required under C. And if you go to subsection C, it says, see the child and decide on the safety of the child. And I think that the language not being congruent with one another creates confusion. So does that mean that if a child reports at school and a CPS worker attempts to go to the school, can the parent, under this right that they're being told, decline that investigator be allowed to speak with the child at school, which is a different location than their home?
So your issue is specific to the parent's right to decline the child being interviewed in the parent's presence versus not being in the parent's presence. Is that correct?
I don't believe that that's what the proposed legislation says.
I would like to understand your opposition because we want the best work product possible. So if your opposition can be understood, perhaps it could be distilled into an amendment. So is your opposition that you have an issue with the distinction between the parent declining if the CPS worker is at their front door, parent has care, custody, access of the child, and says, no, you may not right now, versus if they access the child when they're not in the parent's presence? Is that distinction material to what you're saying?
I think it is partially material, and I know that Diana is present. I know that she's worked very hard, as well as DHS, in proposing amendments that address the concerns that we've all discussed in terms of making the language congruent with what the current statute is. I don't know if that's been shared with
I appreciate your testimony.
Senator,
Thank you. And I do have a question for Diana, if I may. Diana, thank you for your advocacy on behalf of children and for your testimony on this bill. I think both sides of testimony help to get to the best work product possible. Some of the testimony in the proponent panel was testimony from parents whose children had been removed from their care. And they talked about their children being placed in a child foster care system. Are you aware of some of the gaps in our foster care system and some of the challenges that we've had with making sure that children in the foster care system are getting services and the attention and getting the opportunities that those children deserve for care in our current foster care system?
Yes, I'm aware of challenges, but I don't know what it has to do with this bill.
I have a second question.
Thank you.
I think it'll clarify.
Thank you.
Several of the parents spoke about had they been advised of their right, that maybe they could have called an aunt, they could have called a grandparent, they could have reached out to a loved one. And instead of their children being placed with strangers and being separated from the love and care and support of a kinship arrangement, that instead their children were taken into a foster care system, which I think we both acknowledge has some challenges that we're working on. But they didn't get that opportunity because they didn't know that they had the right to do that, or they could call someone who could help and who could keep those children with family. Do you think that there are benefits to children being able to stay with healthy family members if they are in a situation where they need to be removed from a parent or guardian that does need to access services for themselves?
If they're vetted properly, yes.
Thank you. I appreciate it. Thank you, Mr. Chair.
Senator. Thank you. I need a clarification before I go on. I've heard so much, not so much conflicting, but probably incomplete. It seemed to me the proponents of the bill discussed anecdotally that that sometimes the department will put an agreement, a binding agreement, in front of the parents during the early stages or initial visit, and that inadvertently the parent has perhaps given away custody or agreed to have the child removed, et cetera, et cetera. So can somebody just answer, is that what happens just generally, is it possible that a person from the Department of Social Services goes in and actually has a document in that initial investigation and a parent could sign it and that child would be removed? I mean, not all the time, but is that possible?
So I will just speak from my experience of being a prosecutor handling child abuse investigations and working with CPS workers. And if I'm incorrect, feel free to.
Yeah, no, anybody can.
My understanding is that during that first home visit, the worker is attempting to assess the safety of the child. If they are able to see the child and assess the safety of the child, many times the child is left in that home. What is usually presented is what's called a safety plan. Sometimes that safety plan would be given to the non-offending caregiver and say, you cannot allow this child to be with the offending caregiver unsupervised. Sometimes it does say, are you okay with placing this child with another family member? Is there an aunt? Is there a grandparent? Is there an uncle?
So we're not going to have time today, but you can see there's a conflict here. I just heard Senator Henson say that parents are not informed uniformly, consistently, and reliably that they have such a right to, I make the suggestion, I mean, it still be up to the government to decide if that aunt or relatives, available. And again, I do not, for me, I don't support the bill as drafted, and I think really more work needs to be done, but there's a very valid point here. And then I'll end with this. I do not know who, drafted these brochures. They're perfectly fine for what they are, but they are not brochures telling parents what their rights are. Now, having said that, we don't have a statewide law that requires every county to follow whatever the public defenders are doing in Baltimore City, and I personally do not want to see that happen because I don't think one size fits all. But I do think that these, at least, are not brochures that I don't think the brochure should be too detailed because the department is not qualified and nor should they be put upon to go through this. However, we could do a better job with these brochures that at least alert parents that they have some rights and that they should make a call or find that out before that initial encounter is concluded or anything signed. But I think we could all agree right there, not that the parent has a right to refuse the child being seen, not this, that, or that. Boy, there'll be a lot of big court cases all around that. So I just make that suggestion to you all, and hopefully I see a lot of nodding heads. All right, thank you, Mr. Chairman.
All right. Seeing no further questions, that'll be it for this panel. Thank you all very much. With that, that'll conclude the hearing for Senate Bill 650. We'll now go on to Senator Henson with Senate Bill 651.
Thank you, Mr. Chairman. Can I bring up the panel? We should have, no ma'am, it's up to you. We should have Jane Sternecki. Yes, understood. Thank you. Thank you. Thank you, colleagues. Thank you, Mr. Chair, Mr. Vice Chair. For the record, Senator Shanika Henson here to present Senate Bill 651, Real Property Transfer on Death Deed. This bill, I'll start off by saying, is a top priority of the Legislative Black Caucus. I think that from the testimony, you'll hear how this bill would be transformative in the way that people are able to transfer property and thus protect and preserve generational wealth. Because of some of the challenges that exist differently in different communities in Maryland, it's a particular priority for the Black Caucus because that need to transfer property and preserve generational wealth can be felt more acutely, particularly in the Black community here in Maryland, but it is a bill that would benefit and certainly impact everyone's ability to transfer property. The way that the bill works is it would create a transfer on death deed in the Maryland Code. Currently, there is no ability to designate a successor, a beneficiary for your real property. We did hear a bill, if these terms sound similar, sponsored by good Senator West, where you could do that with a boating vessel, but we've not yet done that for a person's home. You can do that with a bank account, you can do that with a number of things, set up a successor, but you can't do that just yet with property without this bill. So this bill would legalize the practice of having a transfer on death deed, but we have some folks here from the Uniform Law Committee that have adopted this legislation in different states who are helping us take that even one step further. It would codify into the code a form for a transfer on death deed, similar to what we've done with power of attorney, similar to what we've done with advanced medical directives, where we have within our own state code provided people the language that they would need to access the legal resource and right that's codified there. So when you flip through the bill, you will see that language appear starting on page 24, where it would be the form language for how we could adopt a transfer on death deed here in the state of Maryland. Actually, pardon me, that's not page 24, that's a prior draft of the bill. You would see that listed in the bill on some page. 20. 19, thank you, page 19, that would give us the ability to codify that into a form so that that would be accessible to everyone who wants to take advantage of it. Now, what it does is it still has some protections in place to make sure that we're protecting against fraud or protecting against folks who would do this with any sort of malintent. So these deeds would still have to be notarized. They would still have to be recorded, just like a deed that transfers property during someone's life. But the benefit, again, is that it would create the ability to transfer this property after death. It would take it out of the probate system, which is where so many families lose access to that generational wealth, is navigating the probate system. So I do believe that this bill will do a lot of good for a lot of Marylanders, and I believe that the panel will help you understand and make the case for that even more. So with that, colleagues, I will ask for a favorable report on Senate Bill 651. Thank you.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the committee. My name is Jane Sternicke, and I'm Legislative Counsel for the Uniform Law Commission. We're requesting a favorable report on SB 651 to establish transfer and death deeds, and thank you to Senator Henson for that great explanation. This act is based on uniform legislation created by the Uniform Law Commission, which is a state-supported nonprofit organization made up of attorney commissioners from every U.S. state and territory. They volunteer their expertise to draft uniform acts. My primary goal today is to provide an overview of the Maryland version of the Uniform Real Property Transfer and Death Act and to discuss some of the adaptations that were made specifically for Maryland today. Additionally, amendments were published just yesterday to address some minor inconsistencies in the bill and with regard to concerns that we heard from the land title industry and the Maryland State Bar Association's Real Property section. As background, in 2009, following 3 years of study and drafting, the Uniform Law Commission finalized the Uniform Real Property Transfer and Death Act to address a growing trend towards non-probate solutions for estate planning. Unlike other states, Maryland does recognize a common law right to transfer property through a life estate deed with powers. In adapting the Uniform Act for Maryland, we acknowledge this, but we decided to leave life estate deeds intact to avoid disruption to attorneys' current practices. Instead, SB 651 creates a new statutory process in Maryland with clear parameters for attorneys and transferors who do not have access to legal advice. A transfer on death deed is ideal for those whose home is their primary asset, who may have beneficiary designations for their bank accounts, securities, vehicles, or boats. Thank you, Senator West. This act allows property to transfer automatically at death to a designated beneficiary. It's a tool in the toolbox for estate planners and families alike. Transfer and death deeds have 3 key fraud prevention mechanisms. First, they are fully revocable until death. Second, they have no effect until death, unlike a joint tenancy. And third, they're recorded publicly in the land records. We respectfully request a favorable report, and I welcome your questions. Thank you.
Members of the committee, thank you for your time and attention. My name is Megan Good. I'm a Tangled title attorney with the Maryland Volunteer Lawyers Service. We provide free civil legal services to individuals throughout Maryland, and my team works to help low-income families preserve and pass on their family home. We're asking for your support of Senate Bill 651 because the transfer on death deed is an important tool for enabling homeowners to plan for and pass legal title to their home, even if they cannot afford an attorney or live in a legal desert. In our work, we meet heirs where the title to their homes are fractured across numerous family members, and the hurdles necessary to move the deed into the name of the acting homeowner are often insurmountable. Tangled titles heighten the risk of housing deterioration and loss because many programs designed to support low-income homeowners are only accessible to individuals when their name's on the deed. The power of the transfer on death deed is its accessibility. Though it serves the same legal function as a life estate deed with powers, a homeowner cannot adequately create a life estate deed without an attorney. In the absence of the transfer on death deed, homeowners rely on advice and forms they find online to create bad deeds that often have errors in them or put their interests at risk. We see this only increasing with the increase in artificial intelligence. The transfer on death deed fills a critical unmet need by providing homeowners with a reliable tool that protects their interests. Another important thing this legislation does is to clarify and standardize recording practices for this deed across the state. Right now, counties have inconsistent recording practices for deeds that provide for a future transfer in property, and this bill makes it clear that any of these deeds could be recorded without needing to address all liens on the property, since the property is not yet being transferred. As stakeholders, we've been working hard to strengthen this legislation, making improvements from prior years, and we have unprecedented support. We support all of the amendments that have been offered by Senator Henson, and we ask for your full support of this bill. I look forward to your questions. Thank you.
Good afternoon, members of the committee. It's a pleasure to be here. My name is Jim Campbell, President Emeritus of AARP Maryland. And good company, I can see, because I'm a former state delegate also, and it's good to see a number of you here that I serve with, Senator from Harford County. And we're here today to strongly support House Bill 651. The bill takes an important step towards simplifying estate planning and easing the burdens of many Marylander families face with death of a loved one. Right now, navigating the probate system can be overwhelming, especially for older adults, people with modest estates, and those without access to legal counsel. For many Marylanders, their home is their most important, valuable asset. Senate Bill 651 keeps those homes in families by reducing probate costs and preventing unnecessary sales. It modernizes their laws in a way that promotes accessibility, fairness, and peace of mind. Senate Bill 651 offers a practical alternative to ensure that everything a family owns is passed on to those they choose without additional burden when the loss of a loved one. So I also am with the City Commission on Aging. I'm a co-chair, and we just think this, not the commission, but AARP, think this is an important bill and urges a favorable report. Thank you.
Good afternoon, Chair Smith, Vice Chair Wallstreicher, members of the JPR Committee. My name is Vanessa Brooks. I am a resident of the 10th District of Maryland and a former resident of Cecil County, and I thank you for the opportunity to testify on transfer on death deeds. This is a personal story I'm about to share with you. First, I want to let you know that the transfer on death deed can prevent tangled titles resulting from homeowners dying without a will and specific heirs. In my family, this happened over several generations. Property passed through Maryland intestate laws to tenants in common that allowed the property to go to forcible sale. My great-grandfather, George Hyman, was able to purchase two adjacent lots, 115 and 117 Milburn Street, Elkton, Maryland, Cecil County, in 1935. My great-grandparents built a duplex. They lived in it, along with two of their four daughters. And then when my grandfather died, he left no will. When my grandmother, Annie Congo Hyman, died, she left no will. The property passed to their four surviving daughters. Two lived in the property until they died. Several of the grandchildren of George and Annie lived in the property with their families until the last grandchild that lived in the property died. For a few years, both properties remained uninhabited. Ownership of the property was unclear. The title would remain clouded regardless of who paid the back taxes on the property. My mother and her first cousin were remaining tenants in common, neither of whom wanted liability without clear title. So the property was forcibly sold for less than $3,000. In short, we lost a family home because of no clear title. The legislation would clearly help Marylander families like mine preserve their family wealth and legacies in the form of real property to designate beneficiaries. The sale of the properties on Milburn Street led to the loss of ownership for all potential heirs and resulted in the loss of intergenerational wealth. The two lots now sell at $90,000. The last thing I would like to say is that when tangled titles leave a family to a home with no designated beneficiaries and that asset is lost to future generations, we fail to preserve intergenerational wealth, and I thank you.
Thank you very much, Ms. Brooks. All right, questions from the committee for this panel. We'll start off with Senator McKay.
Thank you, Mr. Chair. May I have a question for the sponsor, please?
Hello.
So are you aware of the Maryland courts, circuit courts clerks, no position but with recommendations?
I think Jane on my panel is more familiar with it, Senator,
Okay.
if you have a specific question.
Well, the only question has to do with is that are there amendments that are going to be incorporate the concerns that they have to make sure that we have land records that are, as they said, reliable, protect property rights, and reduce the opportunities for fraud.
Yes,
That's
but
all.
may I have Jane address that in a little more detail? But the short answer is yes.
I'd rather listen to you, but okay.
Thank you.
I appreciate you accepting me as a cheap imitation for our sponsor. So there are a couple of ways to address these concerns. So the first one is that we need more clear procedural safeguards for deed fraud. As I mentioned in my introduction, this is about as clear as it can be from a deed fraud perspective. Mandatory notice is unacceptable to the Uniform Law Commission because it adds additional opportunities for clouded title and additional opportunities to contest the transfer and death deed. And we really want this to be something that in the vast majority of cases will be upheld in court and in fact avoid litigation altogether. Second, regarding the tax certification, yes, that is an amendment that we're currently working with our friends in the land title industry to come up with, and we're hoping to have that shortly. Same with the legal description requirements for meets and bounds, LIBOR and folio numbers. Regarding the notary requirement, that's already there on the form. There's an acknowledgement section, so I think that was just a totally understandable misunderstanding of the act. On their fifth and sixth concerns, so the fifth concern really is back to that delivery issue, and it is our strong position that delivery should not be mandatory. The sixth concern is addressed by the tax affidavit, and then that seventh concern about ambiguous language such as or other individual authorized by law, we totally understand that that's ambiguous, and we would be willing to make an amendment there as well with the sponsor's permission.
Thank you, Mr. Chair, for the
Thank you.
grace.
Thank you, and I'm asking on behalf of Senator West. You all already addressed the circuit court, a clerks association, but he was also asking about the judiciary's comments and if those have been addressed.
Yes, so I spoke with the person who submitted that after we saw it was submitted, and they were submitting that information really in echoing of what they had heard from the clerks. So they didn't have any additional concerns beyond what the clerks had communicated to them. Last year, when this was introduced in the House, there was a requirement that the courts produce documentation that would help educate the public about the deed, and they were really concerned about that. We removed that from this year's requirement because we felt that the statutory commonly asked questions form was providing adequate guidance, and we also strengthened that form this year to have more information that was specific to Maryland and the questions that we frequently see from low-income homeowners trying to understand what their options are for a deed.
With this deed, would it be filed as a supplement? Let's say I wanted to follow this process. Would I attach this with that fee simple deed that I have, or would this be the deed? I mean, how does it operate?
Yeah, so the statutory form is the deed. So you would need to, if you were a homeowner and you wanted to make this deed transfer on your own, you would need to get a copy of your current deed to be able to reference it, to copy over the legal description of the property. And the commonly asked questions answers some of those common questions, like what do I do with this? So you need to go to land records and record the deed. Land records has an intake sheet. I don't know if anybody's ever recorded a deed, but there's an intake sheet you have to fill out that has key information about the property, like the property ID number, who's the deed from, who's being named. You would still have to fill all of that out. So the process for filing the deed is standard. It follows current practice.
So the taxation and all that stuff would still happen, at least up front, I'm assuming.
So there would not be taxation for this type of deed because it's called a no consideration deed, meaning there's no money being exchanged, right? Like just like when you name a beneficiary for your life insurance policy, hopefully somebody's not paying you to do that, but the idea is you're acting on your own to take this act, and it's revocable. So the transfer is not happening in this moment. So when you name a beneficiary on the deed, they have no right to your property in that immediate moment. They only have a right to the property, and they inherit it automatically once you pass away in the future. So when I go to record this deed, and if anybody here is familiar with how deeds already work, it is very similar to the life estate deed with powers. When you go to record it, there are no transfer taxes due because there's no sale. And there's also no recordation taxes because there's no sale. There's no refinancing of mortgages, things like that. It's just like recording a document. And then if there are potential inheritance taxes due, that would occur when the person passes away. And that is a common question. So that's one of the questions we added to the commonly asked questions guide of, does this impact inheritance taxes? And we were clear that no, this does not like get you out of inheritance taxes.
Okay, that's
So
that
when
was
you-
my next question.
Yeah, so when you record the deed, you're paying the fee to file it with the Land Records Office.
Okay, thank you.
You're welcome.
Thank you, and thank you for the bill. You can follow up with me on any of these questions, but I just wanted to make sure I understood something. Something that caught my ear was somebody said a life estate with powers you cannot create in Maryland without an attorney.
Yeah.
Is that a law?
It's not a law. So as we've worked through this, we've been talking amongst ourselves as attorneys, and Delegate Phillips, who practices in this area, was like, I've never seen a life estate deed that somebody did on their own. And I did this past month C1 for the first time. So it's extremely rare. When I said you can't do it without an attorney, I mean just practically, you can't effectively draft it without an
And why
attorney
is that?
because
Why
it's
would
so
you say-
difficult. It's difficult. So if somebody's doing it without an attorney, generally we see quitclaim deeds that they're finding a form online, or maybe a joint tenancy, they're adding somebody as a co-owner. With the life estate deed, and just if folks aren't aware of what a life estate deed is, it's very similar to the transfer on death deed. It allows somebody to retain power over the property today as what's called the life tenant. You have property as long as you're alive, and then when that person passes away, it passes to the remainderman. So the practical challenges that we see are you can't avoid these legal terms that don't make common sense to people.
Okay, again, you can follow up in more detail. I just wanted to clarify because I didn't think the statement was accurate.
Got it.
True,
Okay.
Factually,
Yes.
technically true. And I'm a lawyer. And
Yes.
all right, I
So
deal
today
with
you
many
can
things.
make
So
your
I
own
said,
deed
Are you
of-
kidding me? I didn't know there was a statute that prohibits. That's
Yeah,
all
I
needed
appreciate
to
you
know.
clarifying that.
So-
Right now, as
That's
a
all I needed.
homeowner, you can make a deed without an attorney, and that goes for any deed type.
I just wanted to clarify that, that's all, because I thought literally, I've been a lawyer a really long time and I never knew this rule or the statute. Okay, so that's all. Then, very briefly, is there any historical reason that we have not had transfer on death type instruments, deeds? This is, if you're honest, it doesn't hurt your chances of the bill. I always just kind of wonder why we've had it in lots of different areas, but not this one. I don't know if it's just old English law we don't bother to change, or if there had been historically some elevation of this relationship to land that required sort of a more elevated approach, and wills versus this. So briefly, if anybody knows, if you don't know, don't speculate. I'll look it up myself. Does anybody know if there's an
So I think
historical-
briefly, it's because we, as Maryland, do have the life estate deed, which functions similarly. So really, it's just this a matter of like the reality of it being an access to justice issue for people who don't have an attorney. And I would encourage you to ask that again when Jeff with the Land Title Association testifies, because they've previously opposed and they're supporting this year. So he might have more
Okay.
insights.
And then, again, follow up, or if it's already in writing somewhere, just tell me that. People mention other states have this model legislation, so that's somewhere in the testimony, a list of those or something like that. I can also find it online, just trying to be really quick with the questions.
Yeah, hi, Senator. It's actually in the Uniform Law Commission's testimony. We have a map,
Okay.
but it's 33 states that allow transfer on death for real property. 22 have the Uniform Act.
Have the what?
The Uniform Act, so the version that we're looking to enact in.
Oh, you mean everybody has this, but they just don't all have uniform acts?
That's right. So some
Oh,
of
okay.
some of them
But
predated.
some of them have life estate with powers, is what you're. Okay.
Yeah, some of them predated the Uniform Act, or they don't use like the exact uniform
Got it.
language, but they do
Okay.
still allow transfer on death for real property.
A technical question and then a final question. Is it possible for someone, especially when we're trying to help people that have perhaps less education and less ability to navigate something like this. Is it possible for someone to make this confusing by just sort of doing multiple deeds upon, or throwing a lot of people in? You could do a deed and say, and I want 5 people, which as my father would tell me, that it was a disaster. He was a lawyer. Disaster. Don't let anybody inherit real estate. 1 person for each piece of property because of the fighting. Is that just possible? I'm just curious.
Senator, of course that's possible.
Okay,
There are
just
always
wanna
going to be potential legal
I know you
pitfalls.
can't keep it from the folly, but
Right.
just was
Yeah.
curious. All right.
May I briefly address that? Because we did try to, some of the modifications we made from the uniform version were to try to counteract that.
Yeah.
So one thing we did was we added to the form itself an extra little paragraph at the top that more strongly cautions somebody to seek an attorney if certain circumstances exist. And one of that is if there's multiple owners or they're leaving it to multiple people, because we really do want them to be advised. The other thing that we do when we see people writing deeds on their own, they don't address what type of joint ownership. If they're leaving it to their 3 children, they're not saying what type of joint ownership they have.
Right.
So we put into the form itself a presumption for joint tenancy, which they can change. But if they're not thinking about it, it's just going to default to tenants in common. And that's where we see really what's driving fractured titles and people losing their family property. So
yes, that's what I'm worried
we have
about.
changed that presumption. We've written in that it would be as joint owners, which means if they're leaving it to 5 children, as they start to pass away, the number of owners shrinks rather than grows.
Yeah, I'm not convinced this will obviate the need for lawyers entirely, but it's, and then, so then just the last one was more, people that have liens, but particularly banks and mortgages. Just very briefly,
the liens stay with the
banks are
property.
very, very sensitive, rightfully so. This is right. So that all follows.
All the liens stay with the property.
Is that clearly required to be? Well, I guess you don't even, the person who's doing this deed doesn't even have to notify anybody. They can do this without ever telling their niece or nephew they're about to get a property and a mortgage all at the same time.
That's correct, and in that way, it functions the exact same way that deeds do today.
Yeah,
Any other
I
type
get it.
of deed
I'm just
doesn't
saying,
require
okay.
that. Yeah.
All right. So, and then I'm going to applaud you. We had a farm. My father practiced, very brilliant man, practiced a lot of estates and trusts and business law and all of that. Easily could have set up things, absolutely loathe probate, right? Loathed it, and taught me to loathe it. So I loathe it too, even if I know how to do it. And this will solve a huge problem because I still own that farm. I'm deeply worried about how I'm going to do it. And my poor father, knowing he was going to die in less than 2 years, and that was a pretty certainty, finally did it, put my name on one deed and my mother's on the other. And I knew it was just hard on him just because he was still alive and he had then basically given away the property as opposed to waiting upon his demise. So I thank all of you for working on this, and you too, Senator Henson. All right, thank you.
Thank you.
2 questions that I believe someone wanted answered, and this can be either for Ms. Sternecki or Ms. Good. How does this year's version of the bill compare to last year's version?
Senator, thank you for that question. I have a detailed list of how this year's version compares to last year's version somewhere. So the Uniform Law Commission actually didn't view last year's version as a uniform act. So there were a handful of deviations that made it ununiform. Those were these following 4 changes. So first, it only allowed transfers from an individual sole owner. So if you were a joint tenant or a tenant in common, you could not transfer your property. Second, the 2025 version included a fiduciary right to revoke. That was contrary to Maryland's trust code. So this version does not allow a fiduciary to revoke a transfer on death deed. Third, the 2025 version did not have an acknowledgement section on the sample form. That was also not in line with the Uniform Act. We've fixed that so that it requires notarization. And fourth, it included a preparer's statement on the sample form for revocation, and we were concerned that that encouraged someone other than the transferor to fill out the transfer on death deed. So those key defects have now been fixed, and as Megan mentioned, we've made some significant improvements to conform this to Maryland's existing policy requirements.
I appreciate that because in that response, you also answered the next question that I had, which was how were the changes made to adapt to the uniform Real Property Transfer on Death Act for Maryland. So thank you.
Thank you.
Excellent. All right. Seeing no further questions for this panel, thank you all very much. All right, is Sarah, that's virtual. Let's see, who else is in person? Is James Campbell?
I just went.
Okay, yep, there you go, delegate. All right, then we will be joined by two guests who are signed up in favor, who are joining us virtually. We hear from Sarah Mancini and, okay, Sarah's not here. What about Tina Nelson?
Your Honor, if I may, apparently my statement or my materials may not have made it as well. I'm Jeffrey Thompson from the Maryland Land Title Association.
Yes, sir, we've got you here signed up favorable with amendments. We're just going to go straight favorable first, and then we'll switch over to you.
Thank you.
Excellent. No, we've got you. All right, is Tina Nelson, Miss Nelson.
Senator, I think she had limited availability, so she may not.
I think she's here. She's
I
in
am here.
Yeah.
Okay, great.
Welcome.
Thank you.
All right, if you can unmute yourself, we're ready to go.
Okay. Thank you very much. And just to be sure, this is for, because I've been on the,
Senate Bill
parking lot for a
651.
while. 651, yes. Thank you so much.
Yes, ma'am.
All right. Well, good afternoon. Thank you for the opportunity to testify on support of SB 651. I am Tina Smith Nelson, Esquire. As a resident of the state of Maryland, I am fully in favor of establishing a transfer and theft deed. As an attorney who specializes in probate and estate planning, I have guided family members and friends in making decisions about creating the essential estate planning documents, including wills and trusts. Many have asked whether there is a mechanism in Maryland to transfer ownership of their home without adding family members to their deed or having them later go through the enormous time and expense of probate to obtain ownership. Having the ability to transfer real property to beneficiaries after death through a transfer and death deed would be a cost-efficient and easy way to affect the wishes of Maryland homeowners. As a senior managing attorney with Legal Counsel for the Elderly, I assist hundreds of low-income seniors in the District of Columbia prepare estate planning documents, including transfer and death deeds. LCE supported the passage of DC's TODD statute in 2013, and since its passage, we have not encountered any negative ramifications from clients utilizing this mechanism to transfer title of their home. In fact, it has encouraged low-income homeowners to engage in estate planning to avoid future heirs property issues, which often lead to the loss of family homes. The addition of TODDs has been a crucial added estate planning tool for our clients, most of whom's only asset is their home. It allows them to pass down their home to their heirs along with the equity in the home, thereby maintaining generational home ownership and wealth. The TOD has worked very well in the district, and I'm certain it will have the same positive impact on the residents of Maryland. They are a simple and effective method to transfer real property at death, and I thoroughly support passage of this bill. Thank you.
Excellent. Thank you very much. All right. So that will conclude the testimony for the proponents of the bill. We'll turn to favorable amendments. Mr. Thompson, come on up. We also have a few people joining us virtually who are signed up favorable with amendments, but we'll hear from Mr. Thompson first. Welcome.
Thank you, Mr. Chair, Mr. Vice Chair, members of the panel. I'm Jeffrey Thompson. I'm here on behalf of the Maryland Land Title Association. And the one thing I will say is those individuals who tell you that they want to find a simple way to transfer real property are guaranteeing that I will always keep my job as an underwriting counsel for a title insurer. Real estate is not simple, never has been, never will be. But this is one tool that is being added to a box to allow people who feel that they can't go to an attorney to be able to transfer property. I thank Jane Sternecki and Megan Good for working with the Maryland Land Title Association as well as the Maryland State Bar Association real estate section to bring to the uniform law those things that are specific about Maryland. As such, we are able to say that we support this bill for the, I guess I'm glad that for the first time in about 5 years, I'm not standing here telling you it'll never work. This will, with the amendments that we've suggested, there is one further amendment that we are working on that we have suggested and are trying to put through, and that is an affidavit. Actually, we're not going to call it an affidavit. We're going to call it a TODD death notification. And that's so that the Judicial Information Systems Office can properly code things. But that will allow notification of the death of an individual so that Maryland's SDAT will get it, so that any appropriate taxes can be triggered, and things will move forward in a smoother fashion. So as I said, we support the bill with amendments. Thank you for your time, and if I can answer any questions, I can, please don't do what my children refuse to do, and that's ask me anything.
I appreciate that. Thank you very much. We're going to hear from our guests joining us virtually, then we'll open it up for questions. So let's hear from Ms. Sneed, Aisha Sneed. Welcome.
Thank you. Chair Smith and distinguished members of the committee, thank you for the opportunity to testify on SB 651. My name is Aisha Sneed. I'm the heirs property coordinator for the Stop Oppressive Seizures Fund. We support SB 651 with amendments because this bill is essential to protecting Maryland's homeowners and preserving generational wealth. Through our work with Adistra, we identified over 8,000 heirs properties created between 1980 and 2024 in Baltimore City. Families living in these homes often face steep barriers, especially probate fees, that make lawful property transfer difficult. A transfer on death deed is one of the most effective tools to prevent these issues before they arise. SB 651 will provide a clear statutory form that makes estate planning accessible, offer a low-cost alternative to traditional legal services, reduce vacancy, deterioration, and tax sale risk, which are major drivers of blight in heirs properties. A TODD is a simple, proactive tool that can help hundreds of thousands of Maryland homeowners protect their homes, stabilize their families, and strengthen communities, especially in historically disinvested neighborhoods. To strengthen the bill, we urge two amendments now. Mail notification to homeowners when a TODD is filed, and to list TODD in the property records, similar to life for life estate deeds. We respectfully urge a favorable report on SB 651 with these amendments. Thank you.
Thank you very much, Ms. Sneed. All right, we'll hear from Comita Gray to round us out, and then we'll open up for questions. Ms. Gray, you're up.
Good afternoon, committee. My name is Comita Gray. I'm the president of the BTB, Brandywine Southern Region Neighborhood Coalition. I'm also the founder of the Two Bridge Community Development Corporation, which has a financial arm. We are here in opposition of the bill unless there are amendments. We have submitted significant testimony to the Judiciary Committee on this TOD bill. It is considerably different from the 2014 to the bill that it is being presented as of today. We are the only representative that I see that has testified that represents actual affected residents. We are not against the TOD bill, but this is not the DC bill. It is not the Delaware bill. There's complications. And when you talk about seniors, it can be devastating if not done appropriately in how they can adhere to this bill. I do not, and we do not as residents, having over 1,500 residents, members just in the Brandywine Southern Region Neighborhood Coalition. We appreciate the opportunity to share these perspectives, and we hope that the committee will ensure robust public education accompanies this new tool if enacted. We also would ask that you consider the 29-page report that we presented on this bill and the differences between the 33 states the difference between DC, Maryland, and Delaware, which was just enacted. We have today submitted extensive comments to the Judicial Proceeding Committee as of today to clarify issues and outstanding on this. Thank you for your time, and I'm happy to answer any questions.
Thank you very much, Ms. Gray. We have a question from Senator James.
This will be super quick. After this, I read the judiciary. I think this gentleman, you already addressed the notice issue, and they have a couple of other issues in here that I'm sure are very easy to fix in terms of what forms and some suggestions like that. So if you all would just take a look at that and get back to us. All right, thank you.
Excellent. All right. I think that's it. That rounds us out. Seeing no further questions, that'll conclude the hearing for Senate Bill 651. Thanks for bringing the bill, Senator. That's good. All right. We'll now go to our final bill of the day. I see Senator Harris is here for your maiden voyage into JPR with Senate Bill 666. I don't know what that portends, but we do have the Reverend, our pastor here. I appreciate that.
I think I'm filled with the Holy Ghost and the Holy Spirit enough to get through this. Well, appreciate it, Mr. Chair. Great afternoon. This does allow me to enter it into my fourth and final committee in the Senate. So you all were the last one, so I appreciate that. Chairman Smith, Vice Chair Wallstreicher, we appreciate you and members of the JPR Committee. For the record, Senator Kevin M. Harris, representing District 27, which covers Prince George's, Calvert, and Charles County. I'm here to present Senate Bill 666, Real Property Short-Term Rentals. I introduce this bill because I recognize that Maryland is in the midst of a serious housing crisis. According to the Maryland Department of Housing and Community Development, 46% of Maryland renters were 46% of Maryland renters were cost burdened, including 49% of Black households across the state. In 4 central Maryland counties, monthly rent exceeds $1,700 per month. According to the Comptroller's Office, the average wage was in Maryland $28 per hour, but the wage needed to rent a two-bedroom apartment was $39 an hour. The difference between what mariners make and how much rent costs means that some mariners are forced to make tough decisions. Will I pay my rent or will I buy groceries? Will I pay my rent or will I buy my medication? Some mariners, however, have found that offering their residencies as a short-term rental creates enough financial cushions that they no longer have to choose between rent or medication or groceries. Unfortunately, certain counties have moved to prevent such practices by banning renters from offering their residencies as short-term rentals, even with the approval of their landlords. Senate Bill 666 is aimed to ensuring that leasing are able to pay their rent by offering their residence as a short-term rental with the consent of the property owner. Senate Bill 666 prohibits the governing body of a county or municipality from enacting a local law prohibiting an operator from offering a property as a short-term rental solely because the operator is a leasing or subleasing. Senate Bill 666 does, however, allow the governing body of a county or municipality to enact a local law prohibiting an operator from running more than one short-term rental in a county if the operator is a leasing or subleasing. Additionally, Senate Bill 666 makes clear that a property owner may prohibit or limit the use of their property as a short-term rental. I say again, Senate Bill 666 makes clear that a property owner may prohibit or limit the use of their property as a short-term rental. Today, I ask the committee for a favorable report so that mariners, renters ain't forced to make a life-altering financial decision every time their rent is due. With that, I refer to my panel and then take some questions.
Chairman Smith. Oh, you're right. I forgot. I'm not at the House. Sorry about that. Chairman Smith, Vice Chairman Wallstreicher, and members of the committee, Jamie Gregory here representing Airbnb. Kathy Bircher is the Mid-Atlantic Policy Manager for Airbnb, is here to answer questions. Senator Harris did a good explanation of the legislation. Simply, it says that if a local jurisdiction allows short-term renting by a property owner, that they cannot disallow a tenant from doing it if the property owner or the landlord allows it. This bill was introduced last year late by Delegate Chris Valderrama. It did not make it out of the House, so this is the first time you're hearing it. One addition to this bill, as Senator Harris noted, is allowing jurisdictions to limit to 1 unit per jurisdiction. That is something that MACO and MML requested. They have officially taken a position of no position this year. And then one other thing, 2 other things. The Virginia state law was passed in 2024. DC City Council is currently considering the same thing. And I will note that in Montgomery County, in their 2023 law that went into effect in 24, they specifically allowed tenants the economic opportunity to be short-term renters. It was at the request of the planning board staff, who noted that 35% of households in Montgomery County are short-term renting. So by disallowing it, you're saying that 35% of residents wouldn't have the economic benefit of short-term renting. And I'm going to stop there and turn it over to Kathy.
Mr. Chairman, Mr. Vice Chairman, members of the committee, Kathy Bircher with Airbnb. I don't have testimony for you. I'm here to answer questions. I will mention that late yesterday, I did receive a letter of support from the National Association of Real Estate Brokers, which is the premier network of Black real estate professionals. It was not able to be submitted. I do have copies, and we'll make sure that you get them, but I am here to answer any questions. And appreciate the senator taking on this issue and patroning the bill.
All right, looks like we have a few questions from the committee. We'll start off with Senator Sidnor.
Thank you. Just, and this is maybe your experts. This bill is drafted to, its aim is to the government, not necessarily owners of property, I'm guessing?
Correct. Correct. It does not change the lease agreement between the property owner and the renter. If the lease agreement doesn't allow subletting, this is a moot point.
Would the lease agreement have to expressly state or prohibit this in order for to ensure that that property wasn't being used as an Airbnb?
That would probably be wise. I mean, most rental agreements in the state have a provision about subleasing, and it is up to the property owner whether they want to allow it or not. It doesn't change the landlord-tenant relationship in any way.
And just so that I'm clear, because I guess I would view, it would have, okay, so the language you put would have to say no short-term rentals are allowed or something like that. I said the language in the lease would have to say that short-term,
I see what you're saying.
Short-term rentals are prohibited.
Correct. Correct.
Okay. Thank you.
Mr. Chair, whoever wants to answer will be fine. Thank you for bringing the bill. In years past, in the city of Cumberland, back in the 20s and the 30s, we had lots of, I'm going to call them halfway houses, where people were renting out rooms and those types of stuff. And one of the complaints or that the city had to deal with was parking congestion having to deal with fire codes and putting many more people into a place that was not originally for that. Have you had any discussions, or has there been anybody brought up any of those concerns that we're creating a unit that it could be possibly not designed for what the building was built for?
So 2 thoughts on that. One, the bill doesn't change the local jurisdiction's ability to regulate short-term renting. And 2, it's already a rental unit. So it's not, you're not creating a new unit.
Well, I will give you that. However, just as these homes that were built years ago, and people were under the same, I believe some of the reasons for this to be passed, of people trying to pay the mortgage and multiple families living in the same unit, ended up creating, to be perfectly honest, there were some fire death traps, and we actually had a couple of these buildings go up in flames and lost, and so the city had to enact laws to prohibit it. I'm just trying to precursor or try to prevent any of that, that maybe if there's been a discussion or anything.
Yeah, well, go ahead. I know where Kathy's going to go with this, but I'll let her do it.
Senator, thank you for the question. An important component of this is that, again, the property owner would have full authority. The person who would want to host their property, once given permission through a lease, whatever method or format they use, whether it's a lease addendum or some other agreement, would have to meet all of the same requirements as someone who is short-term renting their home. And so they would have to meet all of that local government's rules and regulations, whether it's a permit or a license or whatever kind of safety components, everything associated with the local rules. That renter who has the approval of their property owner to short-term rent would still have to meet all of those same requirements.
Okay. But in the synopsis of the bill, it says prohibiting the local governing body, county or municipality from enacting local law or ordinance prohibiting the offering of certain residential properties as short-term rental by an operator solely because the operator is in a lease or sublease of the property authority, blah, 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 blah. I hear what you're saying, but in the case scenario that I'm bringing up, honestly, it was probably not good property owners who were trying to not circumvent, but didn't understand why this should have been prohibited, but yet they created it anyway.
So let me, I think adding on to one thing that Kathy said is that, again, this doesn't prevent the local jurisdiction from regulating short-term rentals in any way that they see fit. It simply says that if the property owner is allowed to do it, the tenant can do it if the property owner agrees. The normal scenario, for example, in Montgomery County is someone's going out of town for a month. They ask their property owner, can I short-term rent it while I'm out of town, or a week or two? That's sort of the normal situation.
No, I get dealing in today's world and the economics of individuals wanting to, for lack of better words, be able to have some form of rental for their unit they may or may not be in. I'm just looking at unintended consequences when it comes to multiple families living in. Granted, it's the property owner has to agree, the tenant has to agree. I get all that. There hasn't been those concerns, and there haven't been those concerns. So, but I thank you.
We have not heard any.
Okay.
Yeah.
Thank you.
On to the bill. It's a good bill. I understand it. I know what's going on in our community. And I want to vote for it. Would you accept my friendly amendment to change the numbers from 666 to 656? Yes or no?
If the number is available, that's something that you all could work on.
We'll make it available. Thank you.
Bless your heart.
All right, further questions for the sponsor or the panel? All right, seeing none, thank you all very much. Thank you. We do have one person signed up. Is Hope Ledford here? Is Hope here?
job, man.
Good afternoon, Chair and members of the committee. My name is Hope Ledford, and I serve as Director of Civic Innovation Policy at Chamber Progress. We're a center-left tech industry association, and I'm here in strong support of SB 666. Our partners include short-term lodging platforms like Airbnb, but they do not have a vote or a veto on our policy positions. I'll make this quick. We respectfully urge the committee to issue a favorable report on this bill to support affordability and to allow renters to be able to afford rent and, in turn, homeowners to be able to retain ownership of their homes. Thank you so much.
Excellent. Thank you very much. Any questions for Hope? All right. Seeing none, thank you so much. Thank you. All right. With that, that will conclude the hearing for Senate Bill 666. All right. And the hearings for the evening, for the day.